Good morning, everyone, and welcome to the 27th meeting of the Justice Committee. We have no apologies this morning. The first item on our agenda is to agree to take item 3 in private. So if members disagree with that, could they just alert me in the chat box online? And unless that happens, I think all members are agreed, so we will take item 3 in private. Thank you. The next item on our agenda this morning is to continue our consideration of the Hate Crime and Public Order Scotland Bill. And I welcome, we've got two panels in front of us this morning, and both panels have multiple witnesses. Our first panel comprises John McLennan from the Scottish Newspaper Society, Lisa Clark from Scottish Pen, Fraser Sutherland from the Humanist Society of Scotland, and David Gregg, who's an artistic director associated with the Lyceum Theatre and many other theatres also in Scotland. Welcome, all of you. Thank you very much for joining us this morning. The way in which we're going to do this is we're going to members of the committee are going to ask questions of the panel, and the members will seek to direct their questions to particular panel members. If any of our witnesses want to respond to a question and they feel that they haven't been given the chance to do so, then please just alert me and alert the clerks through the chat box on the BlueJeans system that we are all using. Hopefully we'll have about an hour and a quarter for this session, and hopefully in that time you'll be able to tell us what you want to tell us about this bill. So can I just ask a very general opening question, and I'm going to go to Lisa first, if I may. And the general opening question is, on the basis of your written evidence, which was of course submitted before the Cabinet Secretary for Justice indicated the amendments that he now proposes to make to his bill at stage 2, your written evidence was very clear that you were concerned that there were significant infringements of freedom of speech in the bill. Have your fears been allayed somewhat, completely, or not at all by virtue of the Cabinet Secretary's proposed amendments? And if I could direct that question to Lisa first, please.
Thank you. Yeah, our submission really did focus a lot on our concerns around freedom of expression, in particular in relation to part 2 about stirring up offences, and the proposal that likely to stir up would be included and that there wouldn't be an intention requirement. Yeah, we really welcome the Cabinet Secretary's amendment to focus on the requirement to prove intention, stir up hatred, and that has eased a lot of our anxieties around the potential for a chilling effect on writers in Scotland. We do have more proposals to make and some points I'd like to raise today, but yeah, as you said, that was a big focus of our submission, and it's been a really helpful development from our point of view, absolutely.
Would you like to outline what the further proposals are that you'd like to see made in addition to what the Cabinet Secretary is already proposing?
Sure. So we are arguing that it would be helpful to strengthen the reasonableness defence by including a new clause that would take account of the literary, artistic, journalistic, comic or scholarly character of behaviour or communication, and that would be on the face of the bill, we would hope, and just provide assurance to writers that that those considerations will be made by the court and that they're not necessarily a target of the bill. We also were keen to have the offences restricted to threatening and abusive, with insulting to be removed. We just feel that that would make the bill more accessible, reduce complexity, and avoid contradicting the logic of consolidation, which we really support in the bill. I'm sure there are other parts that will come up, in particular around part 4, and offences related to theatre and public performances. We also weren't convinced about the need for that. But yeah, having the move to intention has definitely been a real positive step from Scottish Pen's point of view.
That's very helpful, Lisa. Thank you very much. Could I ask the same question, please, to John McClellan? I can't hear John. It looks like he's been unmuted, but I can't actually hear him. Can we check his sound, please? I'm not getting anything. Listen, John, while broadcasting fix that issue, I'm going to ask the same question instead to Fraser Sutherland, please. Fraser.
Hi there. Yeah, I think just to echo some of the points that Lisa was making there, it's very welcome. Obviously, the changes to remove the likely to and just stick to intention. I think the initial concern was that having things as likely to would just have such a worrying chilling effect on free expression, particularly for artists and others, as Lisa's pointed out. And the only thing, however, that I still would make the case for, and we made this obviously in our written submission, not only to the committee but to the Scottish Government prior to the bill being launched, was to try and echo what's in the Religious and Racial Hatred Act in England and Wales for the freedom of expression clause, particularly around religion, which is much wider in scope than what's in the current freedom of expression clause. So it, for example, talks about prohibits or nothing in the bill prohibits or restricts discussion, criticism, expressions of antipathy, dislike, ridicule, insult or abuse of a particular religion or the beliefs or practices of their adherents or any other belief system or practices, etc. And I think that just underlines some of the points that the Justice Secretary himself made. Is, this isn't about controlling people's ability to have discussions about religion or issues surrounding religion, but it's to protect people who are religious from acts of hatred, and I think that's a laudable aim. But we should have it on the face of the bill actually what the Justice Secretary is saying, and I don't see that at the moment with what we have. And also just to add to what Lisa was saying and adding my comment too about the insulting, I don't think it would be helpful to include insulting in the bill. In fact, and I'm just talking from my own perspective from religion because that's our particular focus. But England and Wales Law Commission has endorsed the view that insulting relating to religion shouldn't really be in there. They've said that ridicule has for long been an acceptable means of focusing attention upon a particular aspect of religious practice or dogma, which its opponents regard as offending the wider interests of society. In that context, the use of abuse or insults may well be regarded as a legitimate means of expressing a point of view upon that matter. So it's just to be careful about the use of insulting around religion, because I know that some other groups have asked for that to be expanded.
Thank you, Fraser. That's very helpful indeed. And could I ask the same question, please, to David Gregg?
Well, I have to admit that I came into this process late, so I don't really know about earlier iterations of the bill. I can only speak to the one that I've looked at. My concern is very specifically about the theatre section, which I suppose I think, broadly speaking, is unnecessary. I think, as far as I can see, theatre is the only art form sort of specifically identified. And I think that by so doing, we sort of create it's as if a solution is being looked for a problem that doesn't exist. I think theatre could be perfectly well legislated for within a general purpose, but by identifying theatre, I worry that a very deep problem is created because, of course, the nature of theatre is people standing up on stage representing points of view which are not the piece. The overall piece does not necessarily have an intention. You sometimes want to put up on stage points of view that we are expected to challenge and indeed disapprove of very wholeheartedly. That's a deep part of theatre since the ancient Greeks, who obviously used theatre to explore taboo and the breaking of boundaries. And I suppose more generally, in preparation for this, I thought very deeply, and I was unable to find, either in Britain or abroad, examples of plays successfully censored that would have stirred up hatred against groups in a way that we might think now, phew, that was great that they did that. I could think of really no examples, whereas I could think of many, many examples of plays that in some way wish to promote or protect or put forward the point of view of some protected characteristic or other that had been censored, and that we looked back and regarded this as a deeply foolish move. I think it's ironic that the definition of theatre in this comes from the 1968 Theatres Act, which removed censorship of theatre in Britain. And I think that I don't see why Scotland would wish to be a place to reintroduce theatre censorship.
Thank you, David. I don't know if John McClellan is back with us, but if he is, then could I invite him to respond to these issues as well? John, morning.
Hello, can you hear me now?
Yes, we can hear you. Thank you.
Hooray, jolly good. I think in broad principle, the update from the Cabinet Secretary was very welcome in that it indicated a sense of direction. But the main concerns that we had really remained. And I think that there was something that Lisa said, which I think was quite important, which was that it would help when cases came to court, that if there had been this clarification. But I think that the main issue here is the processes that lead up to court. We're talking about defences and exceptions and things like that. As cases are being investigated, and I still think there is a significant danger that it will make institutions like ours and everybody else involved in communication still open to investigation and action, even if those actions were subsequently unsuccessful. The process of investigation and all of the consequences of that are as serious as being convicted, and can result in people's lives being put on hold. People who have led law-abiding lives and have done nothing wrong, finding themselves on the end of police investigations, and that remains a huge concern of ours, and something which, just despite the reassurances given, which, as I say, were welcome, hasn't gone away.
Okay, thank you, John. I'm going to ask Annabel Ewing now to pick up the questioning, and then after Annabel, it will be Liam MacArthur, please. Annabel.
Thank you, convener. Good morning to our panel. I've got a specific question which I think would be probably directed to John McClellan and then to Lisa Clark. And this concerns a recent suggestion that the possession of religiously inflammatory material would somehow be subject to destruction, and the material itself. And of course, if we look further of the border, we see that a not dissimilar offence had been introduced in England, I think in the 2006 Act referred to already. And so that offence has operated in a slightly different way, but has operated since 2007 in England and Wales. That is the possession of religiously inflammatory material. And as far as I'm aware, there's no evidence that anything has been subject to being destroyed. And I think it's the same position that pertains with regard to the possession of racially inflammatory material. And that, of course, has been an offence across the UK for many decades now. And again, no evidence that any material has been destroyed. Should we not be having this debate in the context of looking at the issue in a temperate, objective way, and where there is, where there are relevant facts to be garnered elsewhere, including in this instance, in terms of the operation of a not dissimilar law in England and Wales? Should we not be, reflecting on that experience to inform our debate here in Scotland?
Well, I mean, I think we're reflecting on all aspects of the proposed legislation. And just because something hasn't happened in another jurisdiction doesn't mean to say it wouldn't or couldn't happen here. And I think in this process, it's legitimate to raise concerns and to make sure that they are subjected to the fullest scrutiny. And I think the other thing is that that the legislation proposed is not the same as the legislation that exists in England and Wales. But I think you're referring to a statement given at the weekend. I can't remember by whom, and I have referred to it obliquely in my written submission. So I think it's while it may not have happened in England, it doesn't mean to say that that it's likely to happen here. It's not likely to happen here. We just don't know that. I think that the job should really be to make sure that for something as serious as this, that the legislation doesn't allow for it at all, that it cannot happen.
Could we hear from Lisa Clark, please?
Yeah, thank you. So yeah, I would echo John's point there. It's definitely a conversation worth having, and we know that for writers, there is a concern for writers that they self-censor the kind of subjects that they explore, the research that they undertake as part of their work, when it's suggested that, you know, possessing certain materials will be held against them in some way. So yeah, we really are keen to have that conversation and make sure that clear guidance is given to, from our prospective writers in particular, about, you know, what this bill actually includes in its scope. And, you know, for example, we're really clear that, you know, having a book in your possession that might hold intolerant views is not in the scope of the bill, but having the intent to communicate what's held in that book and to promote what's inside it is something completely different. So it's a definite, I would agree, it's a conversation worth having, and it is a serious issue. And yet clarity, I think, is what's needed to ensure that a unnecessary kind of chilling effect on the issues that writers and journalists explore isn't allowed to develop.
I thank both witnesses for their responses. I appreciate time is very tight this morning. I would just say that, yes, absolutely, I'm not suggesting we don't have a conversation. It's just, I was suggesting that it would be perhaps not unhelpful to look and see what has happened in other jurisdictions where, you know, essentially similar provisions have been the case, and across the UK in terms of racially inflammatory material. Of course, that has been the case. I just wonder if there's such a concern, you know, presumably there would be a lobby to amend the relevant legislation in England and Wales if there's such a concern about this particular provision. I don't know if John McClellan has had any involvement in attempts to lobby to amend legislation south of the border if this is such a huge issue of concern to him.
No, I've not. But what is of concern to me is in other investigations where we have seen the seizure of computers and phone records and things like that. You know, in an investigative process, and that's one of the big concerns about this legislation as a whole, is that kind of process would be widened. So I still, you know, hold to the view that just because something hasn't happened somewhere else doesn't mean to say that different legislation won't produce the same the effect that we fear here. And I mean, I agree with you that all aspects of the principle should be explored. But to say that it cannot happen because it hasn't happened in England and Wales, I think kind of misses the point.
I would just suggest on the balance of probability, one has to look at these issues. One doesn't have a crystal ball in life, but I think the answers have been very interesting, and thank you, convener.
Thank you very much. I mean, of course, one difference between the provision in England and Wales, one material difference between the provision in England and Wales and the provision in the bill is the extent of the free speech protections, which, as we've already heard this morning, extend in England and Wales to antipathy, dislike, ridicule, and so on and so forth, rather than merely discussion and criticism. But that is an issue that perhaps Liam MacArthur wants to take up. But in any case, it's his turn next. Liam.
Thanks, Convener, and yes, that was precisely the segue I was going to refer to. I think Fraser Sutherland already mentioned some of his concerns around the need within the bill to extend the provisions in terms of freedom of expression. They apply in a couple of areas, but not across the board, and we've heard quite serious and consistent concerns in that regard, and perhaps a suggestion that we should be perhaps adopting the approach taken in the legislation south of the border. The Cabinet Secretary, as witnesses may well be aware, had conceded a willingness to look at both broadening but also deepening those freedom of expression provisions within the bill. So I was just wondering what the panel thought of that, and I think maybe start with John McClellan on this.
Liam. So, sorry, could you repeat the question, please, Mr. MacArthur?
No, John, it was just in relation to the freedom of expression protections. The Cabinet Secretary had indicated a willingness to look at both broadening the way in which the protections apply, but also deepening them as well. I was just wondering whether or not this was something that you would support, and what you would envisage that involving.
Yeah, I mean, the fundamental problem we have is that these are defences and not exemptions. They don't prevent investigations, and we know from experience that it's all very well to include defences, but the defences will still involve you in a very tortuous process in proving that the defences were legitimate and that charges should not be brought, or indeed that a case would ultimately fail if it went to court. And our position is that the bill doesn't present absolute exemptions. It presents defences, and the two are not the same. So while the Cabinet Secretary's announcement was welcome, it would not prevent investigation and indeed prosecution. And that's we as I said in my written evidence, we have seen people, something like 57 journalists who were investigated through breaches of alleged breaches of existing criminal law, whose lives were put on hold. While investigations went through and cases ultimately went to court and failed, or were dismissed. The legislation has the potential to do that, even if every case that came forward ultimately did not result in a prosecution. It's the process of reaching that point that is a significant concern for us. People would be put through the mill to prove that they had nothing to answer for.
I wonder if I could ask Lisa Clark for her view on this.
Yeah, so our submission didn't consider the investigation stage as much as John's did, but yeah, I would. We wouldn't want to see an undue burden placed on journalists. We know from our work on defamation reform that when legal action is brought against a writer or a journalist, that can be a lengthy, costly process. So I would certainly be open to learning more and offering further clarity on that point that John's just raised, although it wasn't a focus of our own submission. Our main argument was for the adoption of a clause on the face of the bill that would strengthen the reasonableness defence. And yeah, as I've already said, just ensure that the court's paid due regard to artistic or literary merit of behaviour or communication. Overall, when it comes to our position around freedom of expression and the hate crime bill in general, we're under no illusion that serious harm is caused in society by hate crime, and writers from protected groups are massively underrepresented in literature and the arts, and those who do have a platform then are often at a heightened risk of abuse afterwards. So yeah, we feel confident that the bill supports freedom of expression for these writers whose voices often go unheard, and that there is the potential there to create a safer cultural space. We recognise the need for writers to hold power to account and to be provocative in their art and their literature and challenge conventional outlooks. And aside from that, the strengthening of that reasonableness defence, clear guidance, accessible communication, transparency about the scope of the bill should support that and ease writers' anxieties about what this bill is really trying to achieve, and create a healthier environment for all writers.
Thanks, Lisa. I see Fraser wants to come in and hopefully add to what he said earlier about these defences and the reasonableness defence as well. Fraser.
Yeah. So I just want to add on to a point that Annabel Ewing mentioned about other jurisdictions. I think there's a lot perhaps that could be learned from the United Nations Human Rights Committee's work and the Rabat Plan of Action, which discusses this particular issue about how you protect people from incitement to hatred, but also balance it with protecting freedom of expression. And they've done a lot of work in detailing out what they've set out a 6-part test and how you balance those two things. And that requires any legislator to consider the context of the speaker, who the speaker is, their position or status in society, whether the person has intent, which we talked about, the content and form of speech, the extent that their speech has, so how many people is it likely to reach, and also the likelihood, including the imminence of their speech. And I think the most important things to take away from the Rabat principles is that they define incitement as statements about national, racial or religious groups which create an imminent risk of discrimination, hostility or violence against a person belonging to those groups. So a bit like what Lisa was saying, we're under no illusion that people are targeted with hate crimes, and that absolutely needs to be dealt with. And I think this bill is the right way to do it, and we support the general principles of the bill. But it's just that balance between, with the stirring up offences, where the freedom of expression is protected as well. And I think the United Nations 6-part Rabat test is something that I would encourage the parliamentarians to have a close look at and try and see if you can replicate that either on the face of the bill or potentially in guidance that goes to police and prosecutors to have a look at that.
That's very helpful, Fraser. And David, you want to come in as well?
Yes, I just want to come in on this idea about sort of nuisance or malicious attempts at using it, where people would probably be found not guilty ultimately, but that the process of investigation would be problematic. And theatre is a very specific example, because obviously a play gets put on, and unlike a book or a film, it's time limited. You put on a play for 3 weeks. And so you become a focus. There's a kind of theatre of protest. And I think that there is a danger that we already see picketing outside theatres as a means of trying to get plays shut down. And plays can be shut down. Jo Clifford, the Scottish trans writer, was picketed at the Tron for her play Jesus, Queen of Heaven. That was in Scotland about 10 years ago, a little bit more. The Sash by Hector Macmillan was picketed by Pastor Jack Glass in the 1970s. In Birmingham, the play Bejti by a young Sikh female writer was picketed by elders in the Sikh community who felt that it exposed, because it discussed sexual abuse in the Sikh community. And of course, Jerry Springer, the opera, we all remember as well, being picketed. And I suppose my point being that it would be incredibly easy for these quite organised picketing events to be supported with a claim that the play under discussion would seek to promote hatred against that particular group, whether it be Sikhs or Protestants, or a religion in the case of Joe Clifford, and so on. And of course, the play might be shut down, therefore, or there could be circumstances in which the producers might decide to shut the play down in order to avoid the costs associated with it. So I just want to identify again, it's another reason to me why I think putting theatre in its own category like that almost creates a target and creates a possibility. And I can think of very concrete examples where prosecutions would be launched because theatre itself is a type of theatre, and often all that people might do, certain groups might wish to draw attention to their cause, even if it would ultimately be unsuccessful.
That's very helpful, specific examples. Thanks very much, Convener.
Thank you, Liam. I think Shona Robertson wants to ask a quick supplementary to John McLennan, and then after Shona, it will be James Kelly, please.
Thanks, Convener. It was just a point of clarification in response to Annabel Ewing. John McClellan mentioned the, I think that was the seizing of computers and phone records. It was to clarify what he was referring to. Is it the existing criminal law, and whether does he think that is something that shouldn't happen, or if alleged crime's been...
No, that's not the point I was making. It happened throughout the phone hacking investigations, and so obviously there was criminality there because 10 people were successfully prosecuted and some went to jail. But in all of the investigations, which stretched to 67 individuals, there was seizure of computers and other materials. And if you create a criminal law, and there's then a criminal investigation, then the seizure of equipment related to that investigation would be an inevitable part of it.
Okay, that's helpful, thank you.
Okay, thank you, Shona. James Kelly next, please. I think James wants to pick up some of the questions about theatres in Section 4. James?
Thanks a lot, Convener, and good morning, panel. The theatrical performances has already been picked up by David Gregg and Lisa Clark, and it's featured quite heavily in previous evidence sessions. So the issue is going to be, how is this dealt with as we progress to stage 2 of the bill and consider amendments? So I wanted to ask Lisa first and then David, in terms of section 4 of the bill, do you think that can be amended to keep it in and make it robust, or do you think it should be deleted in its entirety, as has been suggested by a witness previously? Okay, so if we can go to Lisa first.
Yeah, sorry. Yeah, it wasn't clear at all to us why plays and public performances were picked out specifically. We didn't feel that there was a clear rationale set out in the policy memorandum that accompanies the bill, and we haven't suggested any amendments to the section as it stands, because we just weren't clear on the thinking behind it. So we would probably come down more on the side of remove the section. We feel that if someone were to use the theatrical platform to stir up hatred against a protected group, then that would be covered by the bill already. So yeah, no amendments to propose from.
Thanks, Lisa. David?
I would concur with Lisa that I think that were theatre to stir up hatred in some way that the bill wishes to stop, I think it would already be covered. I think that therefore I think that it should be struck out. And the only thing I can think of in my investigations, I came across a case in Germany where a neo-Nazi group described a rally that they held in order to try to defend against a similar event of stirring up hatred. They said that they had been putting on a play, So there was a sort of weird reversal. They were unsuccessful. That defence did not work because they were not putting on a play, and it was obvious that they were not. But it seems to me that there is no great need to identify the putting on of a play as any sort of separate category, and that by doing so you sort of almost draw attention to and create a circumstance where that will become a focus in a really problematic way. And I just return to the fact that if I wish to stir up hatred, a play and theatre is just about the last way I would try and do it. That it's a very, very, just the very nature of dialogue and of indeed the whole cost of putting on a play. There's so many reasons why it's a very unlikely format. So I just think the easiest thing would be to strike it out, and I don't think there would be any danger of a resulting gap being left.
Thanks a lot, convener. That's me.
Thank you very much, James. It is beginning to feel, isn't it, this particular aspect of the bill, that it's what's the expression, an analogue offence for a digital age. Liam Kerr wants to ask a series of questions relating to the stirring up offences too, and then after Liam, it'll be John Finney, please. But Liam Kerr first.
Yeah, thanks, convener. I'll direct just some specific questions, if I may. John McClellan, I may come to you first. You talked about cases coming to court earlier on. Could you, I know you've done this in a submission, but I'm quite interested to hear you elaborate. If the bill comes in as drafted, then presumably if I'm offended by something in a newspaper column I read and decide that it's hate speech, then presumably I can report that, but I report it now as a potential crime. So in such circumstances, what would happen to the paper or the columnist, particularly that is different to the current civil processes and penalties? And what do you think the impact would be on that columnist and or the newspaper's willingness to put forward such views in the future?
Well, I mean, straightforwardly, there'll be interviews under caution. I mean, that's the starting point. I think I've written about this, in fact, in where somebody with my council hat on, somebody in my ward was had a complaint put against him for a post on social media. This was a man in his 70s. And he ended up being interviewed under caution in St Leonard's police station. Now, nothing came of it. It was dismissed, but nonetheless, a man in his 70s had to turn up at a police station with legal advice to be questioned by police officers about something he'd posted on social media. That's what this would produce. So you would have editors and journalists interviewed under caution if a complaint had been made, because the police would be honour bound to investigate. The implications of this are huge, and we know that, for example, in the past year, there have been 21 complaints to the regulator under their discrimination clause from groups of people not related to the particular subject of the article. And most of those could be raised in Scotland under the proposed legislation. The police, once there's an allegation of a crime, the police don't have much of a choice whether or not they dismiss it or not. They have to investigate it, and we see that with new legislation where it's something as mundane as change of speeding regulations. When a new provision is brought in, the police are automatically under pressure to make sure that the legislation has been worth it and are checked upon to whether or not they have been following the new instructions. So therefore, there would be, it's my view that there would, if this legislation was passed, there would be pressure on police to make sure that they investigated properly any complaints that were brought to them. And we know from the existing case book that there are lots and lots of these kind of complaints happening all the time.
Just arising from that then, John McClellan, so if we say, so you said there were 21 complaints to the regulator at the moment, presumably that there's a civil penalty to that. We know from Section 3 8 that potentially under a criminal penalty there could be conviction on indictment to imprisonment for a term not exceeding 7 years. If that's right, then what impact, the second part of my question, what impact would that have on the willingness of the columnist or the newspapers to publish in the future?
It would be a brave person who would risk going to jail for 7 years for something that they had written. The problem here is they wouldn't necessarily know they were committing an offence when they wrote the piece and when it was published. It may well be that your view is that what you've written is fair and balanced, but then somebody else takes offence and claims that it's in breach of the law. Therefore, the police would if a complaint is made to the police would then have to investigate it. So even if you accepted that there was a chilling factor and you did everything you could to make sure you stayed within the law, there still wouldn't be any guarantee your complaint wouldn't be lodged. But I mean, in broad terms, I think most publishers would seek to avoid a situation where they were embroiled in repeated and lengthy and costly investigation. And it's not just the likelihood of a sentence at the end of it; it's the cost of dealing with the process of proving that you had not committed an offence that's just as big a danger as the sentences themselves.
On that point, then, two brief questions, convener, to Lisa Clark of Scottish Pen. Lisa, as drafted, then, coming at it from a slightly different angle from John McClellan, what's your view on the impact on writers potentially being held criminally accountable for how their work is interpreted or misinterpreted by others?
The first draft of the bill certainly raised a lot of those concerns for us, because there was that openness to the way that your work is perceived by others, regardless of your own intention. That's now been clarified, and we feel that the requirement to have it intended to stir up hatred does limit the scope of that a lot, in a way that we find helpful. I would also just note that the clause that we have called for that would strengthen the reasonableness defence, that would be available to everyone at all stages of the process, so that would include the police. It wouldn't just be reserved to the final court decision. So we would hope that guidance and training around that clause would be helpful throughout that process to ensure that journalists writing in the public interest are considered as part of that. We don't have our submission didn't focus on that kind of preemptive impact on the cost to news outlets as such. So I wouldn't like to speak too much to John's point. But yeah, for us, there is always a risk that writers self-censor, and that there is a chilling effect on the issues that people choose to explore in their work. But we feel that clear guidance, accessibility about what this bill is trying to achieve would help that.
Final question from me, please, convener. Lisa, I'm very grateful for the answer. You've mentioned a few times earlier and just there about the reasonable defence. Just taking that on, do you have any comment on the burden of proof under the reasonable defence lying on the defence, or is it your view that could be reworked to be more appropriate?
Yeah, I think that's a good point. And it's not something that we explored in our submission, but I could certainly see how that would be helpful to explore. And we'd be open to undertaking further consultation around that point if it was felt to be helpful. Absolutely.
Convener, I have no further questions unless anyone else wishes to take that last point.
Thank you, Liam. That's very helpful indeed. So far, we've been focused on the stirring up offences in the bill, but we're now going to move on to look at other equally important elements of this bill. starting with the statutory aggravation factors. And I think John Finney and then after John Shirley-Robertson have questions about this. So, John, over to you, please.
Thank you, Convener. If you allow me a bit of latitude here, I want to draw from Ms Clark's use of the term chilling effect, which has been used several times also by Mr McKinnon, and particularly, if I may, to Penn's evidence, where they refer to a report was done with colleagues of the University of Strathclyde termed Scottish chilling. And this says, as you articulated, when writers feel their work of communication is being monitored by the state, they're more likely to refrain from writing about sensitive subjects, or in some cases, refrain from writing at all. That's entirely understandable. The examples given were Soviet Union, China and Iran, but your evidence goes on to say questions of the harms caused by widespread surveillance in democracies is underexplored. I wonder, do we infer from that you believe there's monitoring with the present legislation? If so, who by and to what extent that influences whether, for instance, prosecutors and police are proactive rather than reactive in responding to complaints from the public, if we may. Ms Clark, thank you.
Yeah, so our Scottish Chilling report, as you said, it does focus on writers responding to state surveillance, and it absolutely is a concern for writers that they inhibit the subjects that they choose to explore in their work. We would absolutely be concerned if there was evidence to suggest that police and prosecutors were taking that active step to investigate in a way that's not reactive to complaints that are being submitted, and that would certainly have an impact on writers across Scotland. Absolutely.
Okay, thank you. I wonder, Mr McClellan, did you have a comment on that at all, please? Whether, under existing provisions, setting aside the additional proposals that we have in front of us here, whether there is any extent of proactivity by the prosecution and police in relation to writing?
No, not that I'm aware of. I'm not aware that the police indulge in regular monitoring of press content for the sake of it, unless, of course, it involves coverage of them. And as we saw from the Emma Caldwell case, that the police are capable of going beyond the law to find out where information has come from. But I think the police learned from that as well. I mean, they were severely criticised for their actions in that regard, and of course there has been a change of chief constable in the intervening time. So at the moment, I don't sense that the journalists working for news publishers are under constant threat or surveillance from the police. My fear is, as the Police Federation have pointed out themselves, that this legislation draws them into that, and that's a great concern.
Thank you very much indeed about that. I'd like to ask the panel, if I may, about racially aggravated harassment. Lord Brackadale recommended repealing the offence of racially aggravated harassment. That's an offence under Section 50A of the Criminal Law Consolidation, ironically, Consolidation Scotland Act 1995. And I wonder if the panel thought, if it was necessary to retain in relation to race, why it's not in place aggravated harassment for other characteristics. Maybe to Mr Sutherland first, please.
I mean, I don't have a huge amount of to say on that, to be honest. I mean, I think what I would be quite keen to see, given that this whole process has been about bringing together all these different pieces of legislation so there is equal, treatment to different characteristics, I think that would be a welcome approach, rather than trying to retain other pieces of legislation. If you're going to bring together a piece of legislation to make it one, then I think it should apply to the different characteristics equally, would be what my approach to that.
Thank you. I wonder, Mr Gregg, maybe not quite your area, but would you have a view on that at all, please? Retaining that aspect simply for grounds of race?
I would, as a person, I agree probably with Fraser. In terms of the theatre, I think it's not. I wouldn't feel that I have expertise on that. But yes, I would have thought that all protected characteristics should be treated equally.
Okay, thank you very much indeed for that. Thank you, Convener.
Thank you, John. Then I think it will be Shona Robertson next. Shona.
Thanks, Convener. I just had a question generally about the statutory aggravations as a general approach to dealing with hate crime. The continued use of statutory aggravations as the core method for prosecuting hate crime has been broadly welcomed, and it was just to see whether any of the panel had a view on this. You're content with what is in the bill in that regard? John McClellan, maybe?
Yeah, no, I don't have any particular comments to make about that. I mean, I would agree with what David and Fraser just said about the equalisation of this. I mean, I think that refers mainly to other offences that are aggravated by hate, and I think that's fair enough. And I know it's a great concern of the police. I'm not sure that it's particularly appropriate to in a news publishing sense, but I wouldn't. I don't really have that much more to add, I'm afraid.
Okay. Anyone else? Fraser?
Yeah, just to add into this conversation, obviously I agree that the statutory aggravation should be the main way of dealing with it, but I wanted to pick up a point around the width of the religiously motivated aggravations and what's not currently included in that. So obviously the case relating to the murder of Mr. Asad Shah in Glasgow, it was not considered a hate crime because his beliefs were potentially considered unusual or unique. And actually at the time in 2016, the Lord Advocate wrote to the Justice Secretary highlighting this, what he saw as a gap in the law, and Lord Bracadale considered it, but he didn't consider it needed to be closed. And that's something that gives me concern for a number of reasons. First and foremost, for people who leave a religious group, they are quite often targeted for violence or persecution, particularly from a closed religious community. And there's a question there as to these so-called apostates, whether they would be protected under the bill, and I think they should be. And I think the Justice Committee would probably agree that anyone who's targeted because they've left a religious group should be protected, just in the same way that if you're targeted because of your religion. But also, I don't feel that actually the current way the law works and what was brought out in the Tanveer Ahmed and Advocate case in 2016, that Article 9 stipulates that everyone has the right to freedom of thought, conscience and religion, and this right includes freedom to change your religion and belief, either alone or in community with others. And Lord Bracadale's taken an approach that only if I can be fair to him, his approach has been that if you're part of this religious community and you're part of a very defined religious group, you are protected under hate crime, and you should be protected under hate crime legislation. But if your beliefs are considered perhaps unusual or quite unique, you shouldn't be protected under the Part 1, the statutory aggravations. And my argument would be, should be protected. We've got, a clear case here. There's not been a clearer case of a religiously motivated killing in the 21st century in Scotland as it was from the Asad Shah case. And it's disappointing that, given the whole review was carried out on the back of that murder. I know that wasn't the only reason it was carried out, but that was carried out because of the Lord Advocate's letter, that hasn't been closed, and I think that's disappointing. So I'd like to see the committee consider that, obviously, in your stage 1 report.
Can I sorry to intervene? Can I just ask, did that case result in a conviction, Fraser?
Yes, so he was convicted of murder, but it wasn't considered. There was no statutory aggravation because it wasn't considered. Essentially,
what was the sentence?
A long time. It was a life sentence, yes, because it was a murder case.
I mean, it's difficult. I mean, given that the function of statutory aggravations is to goes to sentencing, and given that there was in any event a life sentence imposed on the convicted individual, I'm not sure that this is a.
The question would be for a lesser. The question would be for a lesser crime. So in the same way that, for example, if you were to vandalise someone's house because they were a member of a religious community, that would obviously be dealt with as a statutory aggravation. Let's say someone's car gets vandalised because they're an apostate of a religion, and then that's not considered a hate crime.
I understand all of that, but I just wanted to make sure that I had not misunderstood what you were trying to say about the particular case that you were talking about, because the particular case you were talking about resulted in a conviction for murder and a life sentence. Difficult to see how that sentence could have been compounded.
No, but there's also a question there as to what the classification. So one of the reasons that the Justice Secretary said for the purpose of stirring up offences is that, you know, hate crime is counted as such, and there's enough statistical evidence there to measure these kind of things. And if there's a case there, I can't give you a better case of a religiously motivated murder, yet it's not classified that in your statistics because it wasn't considered a hate crime. That's the point I'm making.
Sorry, Sharon, I cut across you there, but I know that Lisa and David want to come in on this as well.
Yeah.
Lisa.
Yeah, just to return to Shona's point, Scottish Pen does support the model of aggravators set out in Part 1. We believe that the consolidation outlined in the bill will make it more accessible and transparent, and ensure that crimes can be identified in a clear and consistent way. So yeah, just to reiterate that.
Thank you. And David?
Just really to point out that in theatre, protected characteristics have been, I think, a very helpful element of our work, in the sense that we identify all the time as to how many plays we put on, by, you know, within certain characteristics. Are we making sure we're looking after people with protected characteristics as we welcome to the theatre and so forth. So I just wanted to separate that out and say that is very helpful, and in general we would support that and consistency of that sort of way of understanding things. It's just very specifically as regards the stirring up hatred element that I wish to talk about.
Shona, do you have any further questions?
No, that's fine, Convener, thank you.
In that case, we'll move on to Rona Mackay next, please. Thank you, Rona.
Thank you, Convener. Good morning, panel. Yes, I'd like to ask about the bill's different approach to race. And I'd like to go to Lisa Clark first, though, and ask her, before I go on to that. Your colleague, Dr. Andrew Tickell, has said in evidence that he thinks this bill is mired in confusion and hyperbole. Can I ask you, Lisa, do you agree with that?
I don't think that the bill is mired in confusion. I think that the surrounding conversation could be argued as such, and I'm going to guess that Andrew Tickell felt the same way. Yeah, there's been a lot of online speculation about this bill, you know, meaning that you won't be able to steal in your own home and things like that, and I actually find that quite harmful, and that in itself contributes to the creation of unnecessary fear and potential censorship of writers. So yeah, I don't think the bill is mired in confusion, but I do feel like the debate surrounding it has been unhelpful, because there's a lot of really great stuff here for writers themselves, and those who do have protected characteristics and have, you know, their freedom of expression suppressed as a result. Yeah.
Okay, thanks, Lisa. Can I ask you about the bill's different approach to race? You know that that this bill would treat race differently, and it would be, you know, there would be the clause of insulting behaviour would be there, and it doesn't require intent. Can I ask you about that? Given that 2/3 of all hate crimes are related to race, do you think that there's justification for that?
Yeah, we absolutely recognise that the reasoning behind the inclusion of insulting behaviour, responding to race-based hate crime is a massive issue that needs to be tackled. We think there are lots of different ways to do that beyond legislation, and I think it's more the fact that insulting behaviour is maybe more of a subjective, less well understood term, whereas threatening and abusive behaviour is already really well established in Scottish law. So we would agree with Lord Brackadale that race should be treated in the same way as other protected characteristics, and that cases that may have come under that insulting behaviour charge being moved to under the abusive behaviour or communication charge would actually be more effective in securing a charge, and we just weren't clear on what specific examples an abusive behaviour charge might not also apply, and we just feel that treating all characteristics the same would reduce complexity, ensure that the bill is really well understood and accessible, and that kind of logic of consolidation is allowed to continue throughout the bill.
Thank you. Thanks. If I could go to John McClellan, please. And if the others want to come in, if you could just put an R in. I'm just conscious of time if the others would like to come in on this subject. But John, can I have your view on the different approach taken to race in the bill, please?
Yeah, no, I mean, I think that Lisa said was fair, and I think just go back on your original point about the view of Andrew Tickell. I mean, I think the bill is not confused. I think the bill is fairly clear. The problem is its implications and its application that's confused and hasn't been properly thought through. It's the unintended consequences of it that concern me. And that's where the problems have arisen.
Can I interrupt for a second, please, John? Is there anything in the bill that you do actually approve of?
Well, as far as the blasphemy and things like that, I agree with that. The problem, as I see it, is that there is a catch-all for news publishers. I'm here to represent the interests of the news publishing industry, and it poses clear dangers for us, and that's why I'm seeking an exemption for legitimate news publishing. So we don't see the need for it in our area. So there are other areas in the bill which don't affect me and which I've not commented on, and it's not for me to judge whether those are good or bad. The bits that affect me, I'm very, very concerned about.
Well, can I just say, I presume that everyone is concerned about protecting vulnerable groups, but can I have your view on the different approach to race, please, in the bill?
I don't have anything particular to say other than that I think that the equalisation of discrimination legislation is a good thing.
Okay, thank you, Convener. Unless anyone else wants to come in, that's me. Thanks.
Thank you very much, Rona. I think Fulton and Annabel have questions now about hate crime characteristics, and I'll start with Fulton, if I may, please. Fulton.
Thanks, Convener, and good morning, panel. I'd like to ask a general question, and that's if any of you have any concerns about the way in which the various hate crimes characteristics are defined in the bill. As a wee bit of background to this, explored issues including the inclusion, or we've had suggestions that there should be inclusion of gypsy travellers, asylum seekers and refugees, and we've also talked a wee bit about the provisions, or there being no provisions for sectarianism in the bill, and I know that that's maybe something that I'll ask the next panel a wee bit more on, but what I'm looking for just now is just some general thoughts. Now, I know that Annabel Ewing is going to come in on the issue of sex and misogyny, so I would be grateful if panel members would take that into account when they're answering me here. And just being cognisant of the convener's earlier remarks about time and the need, or the no need for every panel member to answer every question, I'm wondering if I could come to Fraser Sutherland and Lisa Clark on this, although John and David, I'm happy to take you as well if you want to come in on a specific question.
I think, Fulton, some of the things that some of the groups you mentioned probably would be considered under, or I would consider potentially could be considered under the racial, in terms of like Gypsy Travellers, for example, if there was, hate crime targeted at them. So I think it's about looking at the width of those thresholds, who's included, because I think there's legitimate concerns from those communities, but I think you probably could catch them as part of the racial characteristic. I wouldn't agree at all with the attempt to legislate for sectarianism as a separate characteristic for a number of reasons. I think in the easiest course, you should just be restricting it around religious hatred, which is what you've got essentially in the religiously protected characteristic. The discussions around sectarianism have been around Christian sectarianism, but obviously there's sectarianism that exists between different sects of other religions, and so if you're then legislating for one particular type of activity and there's other sectarianism that exists, I think that would be a mistake. A much wider catch-all religiously motivated hate crime is a much better approach, I think.
Yeah, and thanks very much for that answer. And if I could just clarify to Mr. Sutherland there that the bill doesn't provide for sectarianism, and we're asking about that. And I think what you've reflected back there has been what we've heard from other witnesses so far as well. So I just wanted to put that on the record as well. Lisa, sorry.
So we didn't respond to the idea of expanding the groups that were protected under the scope of the bill. I understand that when it comes to the potential to add in a misogynistic harassment charge at a later date, that's currently going to be under the consideration of a working group, and I suppose that we would just be keen to hear from experts on that issue, working in gender-based violence and violence against women settings, before taking a view on that, and that applies to other characteristics as well. We would welcome evidence from people who are working with those communities before taking our own stance. So that's where we're at.
Okay, thanks very much. Convener, I'm happy to ask other panellists if they've got something they want to say here, or it might be that they, to save some time, they could come in when Annabelle asks her questions as well. So I'll leave that to yourself, Convener.
Thank you, Colton. They haven't indicated that they want to come in at the moment, so I think I'll ask Annabelle to pick up the questioning from here. And unless any other member wants to come in after Annabelle, these will be the last questions to this panel. So Annabelle, over to you, please.
Thank you, Convener. Just returning to the issue of the characteristic of sex in terms of those protected under the bill as currently drafted. I hear what Lisa says. I mean, it's a fairly notable exclusion from the bill at the moment that the characteristic of sex is not currently included. And I just wonder if either Lisa, who has made a few comments already and who's wanting to see what the upshot of the working group will be, and indeed Fraser Sutherland would have any comments on whether they feel this is the best approach given possible timing issues, where they see this working group taking the necessary time it needs to do its job, but that may take us some years down the line, and in the meantime we may well see this legislation in place without the characteristic of sex being included and therefore protected in terms of the aggravation and stirring up offences. I just wonder if we could go to Fraser Sutherland first and then maybe return to Lisa on this point. Thank you.
I think that's a reasonable concern to have, that you've got this gap in the legislation, because what the point I've made all along is there should be equal protection for each characteristic. Although I do have a lot of sympathy and I have a lot of respect, obviously, for the women's organisations that have approached the government on the aim to have a misogynistic crime and the reasons for that, and I understand their reasons for that. So I would probably err on the side of caution and obviously hope to give that working group some time to work out those issues and look to what they want to have. Just on this specific issue, though, something I wanted to raise that is about protests that happen outside maternity hospitals and maternity wards and clinics. So around 7 of these in Scotland are subject to anti-abortion protests, and that's the kind of thing that I think this kind of misogynistic hate crime could help tackle, because it is exclusively targeted harassment at women, usually pregnant women, and it's based on the belief that the protesters' belief that women should be mothers and they shouldn't have abortions, and leaflets containing distressing false information handed out. Abortion and miscarriage patients are approached and followed, and women who aren't even accessing services, particularly those with children, are also stopped. Now, this is something that obviously, members of the Justice Committee will know that buffer zones and things like that have been introduced in England and Wales, but I wonder if it's something that perhaps the committee might recommend that the misogynistic working group look at as well, given that this bill is also a public order bill as well as a hate crime bill, because I think it is a serious concern for a number of women.
And Lisa Clark?
Yeah, I think it's completely understandable that that the working group would like some time to consider this. Gender-based violence is kind of poorly understood in society, I would say, and in terms of having access to evidence about women and women's experiences. We understand that for women writers, there are specific issues around online harassment, and there are specific issues that face women in all walks of life, but it's a very complex area, and I understand that some women's organisations have raised concerns about whether putting a misogynistic harassment charge within this legislation is the best way to tackle these really nuanced issues that spread into all aspects of life. So, yeah, really keen to learn more from the experts in this area, and no real objections from us about the time that it takes to fully consider these really serious issues.
Well, I thank both witnesses for the responses, and with regard to that suggestion from Fraser Sutherland, equally it would be entirely appropriate, I would have thought, for the Humanist Society itself to make suggestions to the working group when it's up and running. Thank you, Convener.
Thank you very much, Annabel. That's very helpful. Do any members of the panel have any other closing issues that they want to share with the committee before we close this session? Fraser, please, and then David.
Yeah, I know you were going to ask this of the second panel, but just to say, obviously, we very much welcome the provision to repeal the blasphemy legislation, having campaigned for it for a number of years as part of the global humanist movement. We campaigned to remove blasphemy laws in all jurisdictions, and so it's obviously something that we're very pleased to see in this bill.
Thank you, Fraser. And finally, David, please.
Yeah, it's just a small point. Thank you for listening to me throughout this. Scotland, we're not just a place where theatre gets made. Because of the Edinburgh Festival, and indeed more broadly, we're a place that theatre comes to. And I just want to really reiterate that theatre is a focus for things because it is a live event. And I think it would be a really sad result of this legislation if, as I think would be very likely, a malicious or sort of nuisance prosecution of a play, perhaps that came to the Edinburgh Festival, or because of a malicious prosecution of a play in Scotland, world attention was drawn to us with a play in danger of being shut down because of some prosecution or other. And because I think it's extremely likely that it would, such a prosecution would not really be within the spirit of what the hate crimes legislation is trying to achieve, but would in fact almost certainly be backfiring on a powerless or less powerful group. I just really want to focus once more on that idea that identifying theatre separately could have really quite wide problems, and I think identifying theatre separately would potentially result in it being picked out because it's a very obvious target.
Thank you very much for those closing remarks, and thank you to all four of you for your time this morning. The evidence you've given has really helped the committee significantly in its understanding of the implications of some of this bill, and we are very grateful to you. Thank you. We will suspend now for 5 minutes just to enable a changeover of witnesses, so we will reconvene at 10:50. Thank you very much. Welcome back, everyone, and we're going to continue our consideration of the hate crime and public order bill now. And we have now in front of us a very large panel of witnesses. And let me introduce everybody before we get underway. We have Anthony Horan from the Catholic Parliamentary Office, the Bishops' Conference of Scotland, David Bradwell from the Church of Scotland, Kieran Turner from the Evangelical Alliance, the Reverend Stephen Allison from the Free Church of Scotland, Ravi Ladwa from the Hindu Forum of Britain, Isabel Ingham Barrow from Muslim Engagement and Development, Ephraim Borowski from the Scottish Council of Jewish Communities, Neil Barber from the National Secular Society, and Hardeep Singh from the network of Sikh organisations. This is a very large panel. If we were all together in the Scottish Parliament, we would be doing this as a round table rather than as a panel as such of witnesses at one end of the table, and that's hopefully how we're going to be able to run it, even though we're all in our separate silos looking at each other on screens. Thank you very much for joining us this morning. We've got about an hour and a half for this session, but even with that time, it's not going to be possible for every witness in front of us in this session to answer every question from every member. So I absolutely want to ensure that by the end of this session, you have all told us what you want to tell us. So please use the chat function that we can all see on the BlueJeans system that we are using. If you want to intervene or respond to a question at any point and you haven't already been asked by a committee member to do so, then please just type R and that's the signal that we will use to indicate that you've sort of, as it were, raised your hand and you want to say something. We're obviously not going to have time to go around the table and make introductory comments, so I'm going to launch straight in. If I may, and ask you, first of all, thank you, all of you, for your lengthy and extremely helpful written submissions, all of which are, as usual, and of course, available to everybody on the committee's web pages. Those written submissions were signed off, of course, before the Cabinet Secretary for Justice indicated that the Scottish Government wished to make amendments to this bill. Many of your written submissions were, like so many others that we've received for this bill, concerned about the implications in particular of the stirring up offences in Part 2 of the bill on freedom of speech. My opening question to you, and I'm going to direct this question first to Anthony Horan, please, from the Catholic Parliamentary Office. My opening question is, to what extent are your concerns about freedom of speech in this bill allayed by the amendments that the Cabinet Secretary has proposed to the bill? So, Anthony Horan, over to you first, please.
Thank you, Convener, and thank you for inviting me onto the panel today to give evidence to your committee. We welcome the Scottish Government's decision to move to an intent-only stirring up offence, and it does go some way to allaying our concerns that we outlined in our initial submission. However, we do still have a number of concerns around the bill, and that is principally around the freedom of expression provisions. We again welcome the Cabinet Secretary's commitment to look at the breadth and depth of those provisions, which is something he's promised to do recently, because right now, as it stands, there is a hierarchy. It's like a gradation of victims, if you like, where religious groups and sexual orientation are treated differently than other protected characteristics, because those are the ones that are explicitly mentioned in the freedom of expression provisions. But I do think that those, as Lord Bracadale said, the freedom of expression provisions should cut across all protected characteristics to ensure equity. I would also say that we do believe that the freedom of expression provisions should be broadened to include expressions of antipathy, dislike, ridicule and insult, which again Lord Bracadale had suggested. And of course it's interesting to note, because the Scottish Government did actually draft those very terms into its original Offensive Behaviour at Football Act in 2012, So it's not something that the Scottish Government is alien to. It's something that they've done before, and I believe they should do so now. And another thing, just in relation to freedom of expression, is to maybe consider the inclusion of other belief systems. So it's not just religions we're talking about, but also to include other belief systems. Again, just ensuring that equity for all protected groups. We still have concerns around the definition of abusive. Again, we just feel that that term could be widely interpreted. So it creates potentially a chilling effect on free speech and free expression. So at the very least, I think it would help for the government to give us some clarity around that term, and maybe to adopt a similar approach as is contained in the Domestic Abuse Scotland Act, which includes a definition of abusive behaviour. And we also have concerns outstanding about the term inflammatory. Now, whilst the move to intent only that the Scottish Government has outlined will protect people from being prosecuted for having possession of, with intent to communicate or communicating harmless material or personally held beliefs, I think the term inflammatory still needs some clarification, I believe, and it'd be helpful to know what the Scottish Government actually means by inflammatory, because what arouses anger or hostility in each individual is very, very subjective. So, for example, some people might feel that some of the views expressed in religious texts or literature, which although widely held by many in society, they may consider them to be inflammatory and may lead to malicious complaints. So we've given the example before of the Catholic understanding of the human person and the belief that gender, it's very topical, gender is not fluid and changeable, and that might be something that could be considered inflammatory by some people and then lead to a police investigation. So just some clarity around that definition might help to alleviate some, I believe, well-founded concerns. And of course, just on the point of the inflammatory provision within the bill, the term abusive still applies to that offence. And as I've already outlined, I think that can still be widely interpreted. And so that's something that we need clarity on. Convener, I do have some concerns around the term insulting and the ratio filling up offences, but I note that Rona Mackay did ask a question specifically on that point in the last session, so I don't know if you want me to hold off on that or if you'd rather me just to go into it just now.
No, I think Rona will cover that ground in due course, Anthony. That's a very helpful introductory set of remarks. I know that Ephraim Borowski wants to come in a second, but before I bring Ephraim in, can I turn first, please, to Reverend Stephen Allison and then to David Bradwell? Same question for each of them as I've already asked Anthony. Stephen Allison.
Thank you, and good morning to everyone. It's great to be here, and we're very pleased as the Free Church to have been invited to give you evidence today and to join with a number of other panellists. We agree mostly with what Anthony has already said, that the move to obviously intention is helpful. There was so much concern over the likely to stir up aspects of it and the unintended consequences of that of course lots of people raised that as a concern, and we welcome that being removed. I guess though what we would say on that is that intention is a legal term, a kind of definition, and it doesn't necessarily mean what common people mean by the word intention. So we do still have some concerns about the use of intention. For example, we looked at the jury manual, which says that intention is a state of mind to be inferred or deduced from what has been proved to have said or done. We know that we can't get inside people's minds, and so the facts and circumstances are what will prove intention, and that could still lead to dispute in court about when was something intended or not. And more broadly, that leads to our kind of concerns over the chilling effect for freedom of speech, debate, discussion being shut down, that we are concerned that people would have to prove defences, they would have to defend themselves in an investigation, they might face interview, they might face material being confiscated or looked at extensively under some of the stuff to do with the possession of inflammatory materials, even if it doesn't ultimately lead to conviction, even if there are good defences or freedom of speech. We in our submission also had concerns that the defences need to be broadened and made more clear. That, of course, we welcome the Justice Secretary saying that he wants to look at that more, and maybe we'll talk about that later. But the fact that these defences still have to be proven or put forward by the accused worries us for freedom of speech. And it also worries us that publishers and distributors of material could be affected by the offences in this bill, because although we might be quite happy to speak and to take the risk, publishers or those who are producing our material may think that they don't want to take that risk, and so again it has a effect on freedom of speech. I also completely agree with Anthony that the statement on religious belief has to be broadened to include other beliefs and those of no belief at all, because at the moment you could read some of it as protecting those with religious belief, but not atheists who we would quite regularly want to debate and engage with and discuss things with, but they might not get the same protections as religious groups. I think that's broadly just some of the things that we still have concerns about. Thanks.
Thank you, Reverend Allison. That's very helpful indeed. And before I bring Ephraim and Isabel in, which I will in a second, can I just hear first from David Bradwell, please, about the same issue? David.
Thank you, Convener. The question about the amendment from the Scottish Government, I would say, yes, it is a big improvement. But I think I'd also say the Church of Scotland is broad and contains a diversity of opinion. So there will be some within the Church who would have supported the original Scottish Government approach, in that it is seeking to overcome hate crime and is responding to the needs and wishes of groups that might be more at risk of being victims of hate crime. I think there's probably a bigger group within the Church of Scotland which were concerned about the potential chilling effect that the original legislation might have had on freedom of expression. I think so long as the European Convention of Human Rights still applies, I think it really is, the risk is only for it being a chilling effect, that people are afraid that particular expressions of religious opinion about other matters might have an impact. But I don't think we want to see these things tested in the courts, and I think we'd rather have a legislation here that really does what it says on the tin, which is protect people from hate crime, and not then getting into the question of freedom of expression. So yes, we welcome the amendment from the Scottish Government, and I'll leave my response there for now.
Thank you, David. That's very helpful. Now, Ephraim, Isabel, and Hardeep and Kieran all want to come in. I'm going to come to Ephraim next, who I think might offer, if his written evidence is something, to go by a quite different perspective on some of these issues. So over to you, Ephraim, please.
Yes, thank you very much, Convener. You're absolutely right in your prediction. But first of all, thank you very much for asking us to elaborate on our submission. I think I would begin to set the scene by saying that the principle that we see underlying all of this is in two parts. First of all, the need for a level playing field with regard to all the protected characteristics, and others have already spoken about that, and that has consequences, for example, with Clause 3 and Clause 5, where race is singled out from all the others. And frankly, it's not that that's a bad thing, but if, as the Faculty of Advocates told you last week, the provision about insulting behaviour has never actually been used, then there's no reason to have it separated out just for race. So that's the first point. The second point is that we need to be concerned about protecting people and not about beliefs or ideologies. And that, I think, was clear in an article by the Commissioner of the EHRC for Scotland in the Herald a couple of weeks ago. So that's by way of background. But on the specific question about intent and effect, I think that the amendment that has been announced by the Cabinet Secretary is retrograde. It essentially provides a get-out-of-jail-free card for something that you will see very often in hate-filled posts on the internet, that people, having posted their hatred, will then end their comments with just saying or just asking. And they are now given a get out of jail free card, because they can say, well, we didn't intend to cause effect, to cause offence. We were merely asking a question about, for example, whether the Holocaust happened. Now, I speak here effectively on behalf of what you might think of as a collective victim group, because unfortunately anti-Semitism is very much on the rise these days, and I take the view, therefore, that it's the victim who needs protected. Yes, freedom of speech is important, but there's a balancing exercise that needs to be done. The right to freedom of speech is not unqualified, and the case needs to be made on a case-by-case basis on what's appropriate and what isn't. And I think there is good precedent for retaining an emphasis on what a reasonable person would regard as a likely effect. That's to say, not some sort of idiosyncratic individual reaction to something that's entirely subjective. But if you look at what the Equality Act has to say about harassment, it quite clearly refers to the effect of someone's conduct. That's, for example, the core of the difference between direct and indirect discrimination. And it says that in applying that clause, harassment is unwanted conduct relating to a relevant protected characteristic that has the purpose or effect of violating the other party's dignity. But you have to have regard to not only how that person sees it, but all the circumstances of the case and what a reasonable individual could have expected. So I think that gives you a middle path that allows you to retain a reasonable likelihood, but not end up saying that anybody who says, oh, I didn't really mean that, simply gets out of jail.
Thank you, Ephraim. And that is quite a different perspective from, I think, almost everything that we've heard in terms of oral evidence so far, not just today, but in the previous 2 weeks as well. And I know that there are several members of the committee that will want to take up aspects of that with you. But before I bring them in, I'm going to turn first to Isabel, Hardeep, Kieran and Neil in that order. So, Isabel, good morning.
Good morning, and thank you very much for having me. I think I'd firstly like to echo a lot of what Ephraim has already said, particularly around the idea of intent. Now, we've already seen in the English and Welsh context since 2006, when intent was brought in for religiously aggravated offences, there's only actually been a handful of cases that have been successfully prosecuted. And that unfortunately, is a large part due to how difficult it is to actually prove someone's intent in a court of law, which puts the thresholds on as unworkably high, which would actually make a lot of the benefit that this bill brings redundant. So we are quite concerned about the inclusion of intent. But what we would say is that there are concerns surrounding freedom of expression, which do need to be addressed. So our recommendation for dealing with that is actually to look at definitions, look at what it means in terms of, for example, Islamophobia and other protected characteristics in particular. Because as two examples, one concern would be an inability to criticize religion, for example. So there needs to be a definition of Islamophobia, anti-Semitism. We've given guidelines on how to enact a robust policy applicable definition of Islamophobia, which would have to include a clause on the exemption of criticizing religion as being outside of the realms of Islamophobia. Another example that I know is causing communities a lot of concern is the idea, the freedom of religious expression particularly within religious texts, and freedom of belief surrounding issues such as sexual preferences, for example. So these definitions need to be robust enough to be policy applicable and written into legislation. I know that the Scottish Parliament has been examining, for example, the APG's definition of Islamophobia for some time, and that COVID has disrupted that process quite heavily. But I think that defining what we mean by terms such as abusive, insulting, reasonableness, or even things like grossly offensive or grossly insulting, we need to be having conversations about what these mean rather than enforcing intent, because intent, I think, will seriously damage the effectiveness of this bill. And as Ephraim has correctly pointed out, this bill has come about due to a need to protect victims. So we need to be thinking about how we are going to maximise that protection without disrupting freedom of expression. And I think by having those conversations around guidelines and definitions as to what is included within the remit of insulting, abusive, against the different characteristics, that is a way to combat that. But also what's important, as a few people have mentioned, is the uniformity. So each individual protected characteristic needs to be given attention in terms of the guidelines and what would be included within the remit of insulting, abusive, etc. But at the same time, the protections afforded to each of those protected characteristics needs to remain the same. And I'm sure there'll be questions later about, racial hatred being a separate category with separate protections. But if we fail to kind of have uniform protections, we risk creating, I believe it was Ephraim who said it in his submission, we risk a hierarchy of inequalities that would be quite damaging for certain protected characteristics.
Thank you. The Law Society of Scotland has also been very strong on that particular point. But the question I just wonder, I don't want you to respond to this now, Isabel, but perhaps next time, as it were, the microphone comes around to you. I'm sure we would all agree that these terms need definition. The question is the extent to which we would be content to leave those questions of definition to the courts, the extent to which we need to define in advance in legislation what all of these terms means. Perhaps we can just reflect on that and come back to it in due course. But I'm anxious to bring in Hardeep and then Kieran and then Neil before moving on. So Hardeep Singh, please.
Thank you, Chair, and thanks for the opportunity to present to the committee today. I think we broadly welcome the modifications around intent. I think that's allayed quite a lot of fears. However, there are still a lot of concerns around free speech. And if I could sort of divide my answer into sort of two parts, I think firstly, we believe there needs to be a strengthening of the free speech clauses that currently exist within the bill. But also the second part of this would be around sort of the specificity of language and wording, which has already been touched on previously by a panelist. The existing bill protects religion and sexual orientation only. And as far as it goes when it comes to free speech, the protections are limited to criticism and discussion. Now, we don't think that goes quite far enough. I mean, if there's more trenchant speech or more robust discussion around certain issues like transgenderism, we think that parallel legislation in England and Wales, I think, which was specified in the previous panel and earlier on, to include words like antipathy, dislike, ridicule, would be a good provision for the committee to consider. And on the second point, we in our evidence to the committee, we made reference to J.K. Rowling and her staunch defence of women's rights, and we believe that people like her have every right to be able to express their opinions freely without sort of fear of censorship, or if this bill saw the light of day as it currently exists, potential criminal prosecution. So we think that the free speech defence should be extended to transgender issues. I want to touch on very briefly, if I may, on the vagueness of words. I think some of them have already come up earlier, but there's a number of words in this bill that require clarity, we believe, from the committee. Abusive, hatred, insulting, inflammatory material. They're so subjective. They can have such a broad interpretation. They're vague and nebulous, which essentially leaves it up to the state or the criminal courts to decide which opinions we can and cannot have. And it's difficult to imagine a scenario where somebody says something insulting which is not abusive at the same time. So there's a real danger that just offensive speech could be caught in all of this. And if you're an activist of any sort, and if you take the view that speech I hate is essentially hate speech, then this bill could be potentially weaponized to persecute your political opponents or opponents in any kind of area. And this is especially bad in such a politically kind of volatile time that we live in. Vexatious claimants, offence archaeologists will benefit from this, as will some lawyers who will further line their well-upholstered trouser pockets. So I think the real issue is around the word hatred as well. We think that there's a really good example in the current provision, the hate crime operational framework that exists in law. There was a case of Harry Miller who tweeted out a poem and was subsequently investigated for what was classified as a non-crime hate incident. Harry took this to court. He had more guts than most people out there, and the judge ruled that there is no right to be offended. But nevertheless, he was still recorded as being somebody who'd carried out a non-crime hate incident. And this is really scary because this would be something that would be on a CRB check would still come up. It could prevent people from getting jobs, etc. So we think there should be really clarity around the definitions of the words here, and we'd welcome any kind of comment on that from the committee.
Thank you, Adi. That's very helpful indeed. Can I turn to Kieran Turner, please?
Okay, thank you, convener, and likewise thank you for the opportunity to give some evidence this morning. A lot of what we flagged up has already been said in relation to intention helping somewhat in some of our concerns. Our big concern the whole way along has always been that people would unintentionally get caught by this. And I guess we all recognise the bill here is trying to do two things, isn't it? It's trying to tackle issues that are causing victims significant problems, significant harms due to stirring up of hatred, but also at the same time we're trying to protect freedom of expression. And we had huge concerns prior to the amendments being brought in that people could unintentionally get caught by this, that balance that Ephraim was talking about wasn't quite right. So it certainly helps having intent there for some, although obviously not all of the stirring up offences have intent because it's not been included in the racial provision. But it's not a magic bullet, and so we still have a few other concerns, and just want to raise two or three of them there. We do very much think that the freedom clauses need to be both broadened and deepened, and at the moment there is that hierarchy of defence or protection. We do think that the depth and the detail of them needs to be better, and again would associate ourselves with the remarks around the section 29 and 29JA of the Public Order Act and some of those other terms that are already applicable, and antipathy, dislike, ridicule, etc. We noted that was actually Lord Brackadale originally suggested that a similar clause should be included, and so we question why that hasn't been the case, or why the similar wording hasn't just been transferred across. Because I think if the new offences are being created, on one hand there needs to be similar level of defences that enable that balance to be struck rightly. I think the second point would be the need in all of this to have absolute clarity on what this bill is trying to catch and what the bill is not trying to catch. And so again, we would agree in terms of the dangers around what are the definitions of some of the key words, and we just associate with what Hardeep has just said on some of those questions. I think there's a question in our mind around inflammatory material and around the view to communicate that, and at what point does possession become a view to communicate, and how is that proved? There's a question in our mind around the dwelling place defence, and we appreciate there are two sides to that, but there's a question there around could those two things be put together to potentially warrant searches and seizures of people's materials within their own homes. And then I guess the final point is just really around the function, I think, of the freedom clauses within all of this. And I think practically they need to be there on the face of the bill to provide that clarity. I noted the conversation last week about Article 10 and to what extent are the freedom clauses needed. But I think where we're looking for greater clarity on the offences that the bill will catch, we need that clarity in terms of the defences that are there in the freedom provisions. But also there is an important, perhaps I don't know if symbolic is the right word, but perhaps an important function of sending a message that I think having the freedom clauses on the face of the bill does, where just as the stirring up offences are there because it's seen as important to send a strong message about what's tolerated in society and what's not in terms of stirring up hatred. So also I think if we're all, which I think all of us on the panel would agree with, want to protect the principle of freedom of expression, so also that principle needs to apply to the defences as well as the offences.
Thank you, Kieran. And then finally, before I move to Annabel Ewing, who'll be next with the questions, Neil, Baba and Ravi Ladpa, please. So Neil.
Thanks, convener. Thanks for asking the National Secular Society to take part in this. The first thing I'd want to say is the concern about that intent is being discussed here. We welcome that intent is being reconsidered. Obviously, it's a step in the right direction. But our concern is that I don't think it's going to be of any comfort whatsoever to the writer or the artist or the playwright who anticipating a lengthy, expensive, stressful, sleepless number of months of anticipating a court case, it's going to be of no comfort whatsoever that if that court case takes place, there's a fair chance that she's going to get off with it. I think what's going to happen is that she's simply not going to make the point in the first place, with the resultant intimidation of free speech right from the start. I mean, lots of people have been saying that today, and I think that has to be considered, especially when you consider that you're going to get some hotshot young lawyer for whom establishing a precedent is going to be her life's work. It's going to be like, I put it to your honour that while clearly there was no abuse, there was obviously insulting, and it's on these nuances that legal sophistry pivots. And I think the fact that it requires a court case to prove intent is not really helpful at all and will intimidate free speech right from the start. The concern, of course, particularly with religions, is that with respect, a lot of religious ideas and sensitivities are quite esoteric. So there's an extent to which you just don't know what's going to be offensive. And again, with a blurring of insulting and abusive, there's more sophistry here. There's more, well, clearly it wasn't insulting, but I put it to you, Your Honour, that there was clearly abuse going on. And, these words are interchangeable, as Hardeep says. They're just too vague. What we'd like to see is, as in England, a much stronger protection. In England, we have protections for expression of antipathy, dislike, ridicule, insult, abuse of religion, religious practices. I mean, in that context, we can draw cartoons of Muhammad. We can make movies like Life of Brian. But in Scotland, which allow only for discussion and criticism, as long as we're polite about it, I think that's going to intimidate free speech right from the start. I'd also like to say, of course, that we're very glad that the blasphemy law is being repealed. We're concerned that this new hate crime legislation isn't simply replacing the blasphemy law, but blasphemy is a crazy idea. Scotland can't go to the United Nations and speak to other countries where blasphemy is a very much more severe offence and say, go and stop executing your apostates for blasphemy, when they might turn around to us and say, well, you've got a blasphemy law, what's the problem? Ideas are not beyond scrutiny. We have to distinguish between ideas and individuals. there's a lot of there's a blurring of the difference between ideas and identity, and somebody who believes that there is that there is an understanding of the difference between religious identity and religious ideas has never been a secular campaigner, frankly. These are the things that are blurred every day. So we need to see a much, much stronger protection of free speech. And we need to bear in mind that, also bear in mind that Scotland today is quite a liberal sort of zeitgeist. But without getting too science fiction about it, imagine in 20 years' time there's a hellish new regime that.
Neil, I'm sorry to cut across you, but we're getting a little bit further removed from the specifics of the bill than that perhaps might be ideal. I want to bring Ravi Ladva in before Annabel Ewing. Ravi, please.
Hello and namaste to everyone. Thank you, Chair, for inviting us to speak today, and thank you for everyone for their time as well. On behalf of the Hindu community, whilst we found issues with the data collection and representations in the legislation, as other speakers have mentioned today, if passed, we feel like it could seriously infringe on the intent to modernise and make fit for purpose hate crime legislation, including, as mentioned, the repealing of the blasphemy law. However, our concerns with the piece of legislation also speak to a societal and individual emotional intelligence, our ability to process complex emotions and deal with difficult circumstances and situations. An integral part of that is free speech and the ability to say what we think, how we feel, and importantly, whether we agree with it or not. To offer a Hindu example and a personal one, I subscribe to a philosophical school of Samkhya, which at its core is atheistic, but it resides in an orthodox frame of Hinduism, along with, the most devotional aspects, including the Hare Krishna, for example. That is only possible through dialogue, which builds an understanding, removes ignorance. I opened with, namaste in this, it's a Sanskrit word, which, essentially is divinity in everything and everyone. That level of oneness is something that we could aspire to. Whilst there are grey areas, in this legislation, which impact and implementation and even enforcement, for us it speaks to an essential part of our social contract as citizens, of the UK and Scotland. Being good to one another. I don't want someone being good to me simply out of fear of what a piece of legislation could do, whether it's tying them up in lawsuits or further consequences like prison. The journey to being good to one another, breaks down ghettos, creates communities and prosperity. If we arrive at a situation where it punishes individuals and groups, it creates ghettos of the mind, and it represses people's personalities. And we see this with the LGBT. For decades, they couldn't be the best versions of themselves, and be all of who they were, and the impact that it has, with how they feel, with suicide rates, and so on and so forth. We don't want to be moving in that direction. Therefore, and it's our belief that we should be looking to build programs and conversations which facilitate, deepening conversations and bonds. Just a final comment on this. This discussion reminds me of a passage from one of our holy texts, the Bhagavad Gita. We're not kept from our goals, by obstacles, but a clear path to a lesser one. And on that note, whilst we as Hindus welcome aspects of this legislation, we should aim to address, specific root causes of hate speech. For us, it's those things that we don't yet understand. And to that end, I would like to see that these discussions, are broadened out and bulk of the public members brought in, so we can engage and really develop the conversation further.
Thank you, Ravi. That's very helpful indeed. Annabel, I'm going to ask you to take over the questioning from here, but what I'm going to say to everybody is that we do need to keep an eye on the time, and if we can have short, sharp questions and short, sharp answers to them, then we'll get through the business. Annabel, thank you.
Thank you, Convener, and good morning to our witnesses and very interesting discussions indeed that we are having. I wanted to turn to the issue of religiously inflammatory material and also racially inflammatory material. In fact, with regard to religiously inflammatory material, of course, that has been, the possession of that has been an offence in England and Wales since, I think, the 2006 Act. I don't recall any evidence to suggest that any destruction of books and religious books was ever proceeded with, and the same with the racially inflammatory material issue, which of course applies across the UK and has done so for many, many decades. I agree that this is an issue absolutely worth discussing, but I wonder to what extent discussions in the context of this bill are informed by the experience elsewhere, including obviously in England and Wales. And I would put that question to, in turn, Isabel, Anthony, Ephraim and David Bradwell. And I do appreciate there are many others who may have a view, and I think if we start with that and we take it from their convener, see what happens next. So if we go over first to Isabel, thank you.
Thank you. So I would say, first of all, on this whole idea of inflammatory materials, we need to have, as I was saying before, this is one of the terms that we do need a clear definition and guidelines as to what constitutes inflammatory. But then also on top of that, there are a number of concerns that do need discussion around the bill surrounding the possession and the disposal of such materials, particularly in terms of, academic research, for example. Quite often people will own materials that they don't necessarily themselves agree with. So these are all areas that I think are in desperate need of discussion. And obviously, just because there isn't any evidence under the 2006 Act that such materials haven't been disposed of, that doesn't change the fact that it could happen. So I think that is something that is in need of careful consideration. And just touching upon Adam's question earlier, I think that these definitions and, more importantly, the guidelines of what sits within the remit of our understanding and what activities are included within the scope of abuse or insult against certain characteristics, I think that needs to be embedded within the legislation itself, so that it is not a subjective decision for the courts to make. If that answers both of your questions.
Yeah, well, thank you. I'm just listening to the responses. I guess, therefore, that there would be a clamouring to amend the 2006 Act to remove this provision, but I don't seem to get the impression that that's the case. But perhaps that's an issue for another day. Perhaps we could go on to next to Anthony Horan, please.
Thank you, Annabelle. I think just because England has experienced it in a particular way, it doesn't necessarily mean that it won't play out differently in Scotland. But as I set out earlier on in my first response, again, the term inflammatory, I think, does need some clarification. What arouses anger or hostility in each individual is very, very subjective, and we're concerned about that. And I think, again, just some clarity around the definitions might help to alleviate some of our concerns. Now, I appreciate, and I think Adam Tompkins, the convener, mentioned this earlier, that where is the line between what the government should, or what Parliament should legislate for, and what is left to the courts to decide in terms of interpreting that legislation? And I think that's probably a matter for political prudence. But it's very, very, very important that we try to make it clear, that line, because I accept that the legislation can only go so far, and then you need to leave it to the deft touch of the judiciary in order to then interpret the terms. So it may sound like a bit of a get out there, but I do think that that's a real matter of political prudence. But we do still have that overarching concern around the definition of inflammatory.
Okay, thank you, Ephraim.
Thank you very much, Annabelle. I think really just echoing what others have said, inflammatory sounds like it's an objective, a subjective term, but this is in the context of law. And as I said earlier, lawyers, as I need hardly tell you, are very used to handling what sound like subjective terms, but are in the legal context objective, because the test that conduct has to satisfy in order to reach that standard is what the reasonable person would regard as meeting that standard. So I have maybe less concern, but I certainly would not stand out against the idea that actually defining it within this proposed statute would be an improvement.
Okay, thank you for that. And David Bradwell, please.
Thanks very much. I just agree with what Ephraim has just said. I think clarity about definition. I can think of documents in the life of the Church of Scotland, like the Westminster Confession, which was agreed in the 17th century. It's an important description of what it means to be a Reformed Presbyterian Christian in Scotland. But there are parts of it which could very well be seen as inflammatory, inciting hatred or causing offence to Roman Catholics. And I think whilst in its current usage and our partnership ecumenically, it's still part of our DNA as a church, and yet we live with it and with our partnership and relationship. So how might such a document be caught by this? I think maybe clarity and definition would be very useful indeed.
Okay, thank you for that. And I see that there's 3 requests for supplementaries, convener. I assume if everybody's brief, that should be okay. First of all, Hardeep Singh, then the Reverend Stephen Allison, and then lastly Ravi Ladva. Hardeep Singh, please.
Thank you. I agree with Anthony on this. Actually, I think we need to have real clarity, and if the Justice Committee could potentially look at what the criminal threshold for inflammatory material actually is, that would be extremely helpful before that's actually tested in a real court case. We think that again, this is in our submission. We agree with many of the Christian denominations around whether or not the Bible or some holy text could be considered offensive material. I mean, especially verses which probably refer to homosexuality as sinful could be caught. But we also, in our written submission, made it very clear that where verses in holy texts actually incite violence or hatred towards non-believers and actually are used for that purpose to stirring up hatred, we think absolutely they should fall under the scope of the bill. One final thought would be, and if there are any exemptions, we'd like clarity around whether or not an academic in a university is sharing Mein Kampf with undergraduate students. Is that an exemption? Or the work of Germaine Greer, which would almost certainly be considered inflammatory material by some transgender activists. It'd be nice to have some clarity from the committee around these sorts of questions.
Thank you. Reverend Allison.
Thank you. I agree with a lot of what's been said already, but just to add a couple of additional points. You made reference to the equivalent provisions in England and Wales. Obviously, they have much stronger freedom of speech protections, and I think that would be required for the inflammatory material in Scotland to be dealt with well. Would be stronger freedom of speech, ridicule, dislike, all the kind of stuff I've mentioned before. Plus, there are the issues around actually putting in the bill that it has to be offensive to a reasonable person and some of that testing. I guess as a supplementary issue, issues of what's inflammatory or offends, abuses people changes over time. And we've seen that recently with some of the ways in which people who have written historic material, novels, those maybe even people like David Hume who are suddenly being attacked for views on slavery, that because people's views change over time and what's acceptable in society changes over time, older inflammatory material might have aspects that we would strongly disagree with today, but we have to see them within the historical context. Of course, in the Free Church as well, we would say the same about the Westminster Confession of Faith. It has to be read within a historical context. And so our concern is that over time, people could see things as abusive and make more use of inflammatory material than may be used today.
Thank you. And lastly from me, Ravi Ladwa, please. Thank you.
Thank you. I'm just going to quickly echo what Reverend Anderson has just said, which is, and to make the point that within history, we see peaks and trends and expansions and collapses of liberalism, conservatism. There is a possibility that if things aren't well defined, we could be cutting ourselves off from lessons from the past. Definitions and the language that is used. I don't know how everybody else feels. I would welcome the opportunity to see this before it's used in the court of law, test trial or anywhere else. And that was the point that we would like to make.
Thank you, very much, Annabelle. I hope that you feel that your questions have been that people have done justice to. Thank you very much. I'm going to bring in Liam Kerr now for a quick supplementary on the back of that, and then Liam MacArthur and Neil. We will get to you soon, but Liam Kerr first, please.
Thank you, Convener. A very quick supplementary, which I'll direct to David Bradwell specifically, please. David, in your remarks there, you talked about a document being, it could be inflammatory to Catholics. Now, given the Section 6 powers of entry that are in the bill, and in their submission, the Free Church comment that only 2 or 3 complaints might be sufficient to apply for a warrant, could you foresee a situation then where the police might enter a church to seize and detain the offending publications that you've referenced?
I suppose I'm not that I can't because I don't suppose I know that much about the aspect of police powers and criminal law. So maybe that's a question that might be better directed to either the police or a legal expert.
No problem. Thank you.
Yeah, thanks. We took extensive evidence from legal experts and indeed from the police last week. So I think we can leave that one there unless anybody else wants to come in. It'll be Liam MacArthur to pick up the questioning next, please. Liam.
Thanks, Convener. Good morning, all. A number of you, in answer to the Convener's original question on stirring up offences and intent, referenced your desire to see stronger protections around freedom of expression, which obviously provides some of the safeguards as applied to the law in England and Wales that Annabelle Ewing was referencing. Without wanting anybody to kind of go over ground they've already covered, I'll maybe start with Neil Barber. The Cabinet Secretary has stated his willingness to look at both extending and deepening the protections in relation to freedom of expression. He's wondered whether you had any comment on that and what you would wish to see in that respect. When we come to Neil Barber first, and after that to Ephraim Borowski, maybe to take a slightly different slant on the same issue. But Neil.
Well, certainly we'd like to see, better, as I said before, better protections for free speech. Again, in keeping with what we have in England, expressions of antipathy, dislike, ridicule, insult and abuse. These all go much, much further than the quite polite discussion and criticism which we're allowed in Scotland. I mean, in terms of the communicating of hateful material, one thing that occurs to me is, I mean, we have Gideon's groups sending Bibles into schools. That's the communication of I mean, we've already discussed some of the texts in the Bible, which the Christian Institute referred to recently as unfashionable texts. Hierarchy of protected characteristics. We saw that in Birmingham. We saw the parents in Birmingham saying, "We're not allowed to discriminate against gay people, therefore you're discriminating against us in disallowing us from discriminating against people." What I'd be interested in how the Cabinet would respond is in terms of for example, what's happening in France. I mean, the drawing of cartoons of the Prophet Muhammad. People have died for that. Is that something which would be described as abusive behaviour and a hate crime? Would that be permitted? under this new legislation.
Thanks for that. Can I maybe turn to Mr. Borowski? And I see Ravi Ladva wants to come in, but Mr. Borowski, I'd be interested in your take on this, given your earlier comments in relation to intent.
Yeah, a couple of points. First, directly on what was just said, there's obviously also been a discussion, and maybe somebody wants to raise it later, about evincing malice and ill will, the phrase evincing malice and ill will, and the suggestion from Lord Brackadale that should be replaced with expressing hostility. Now, I think I understand malice and ill will to be ordinary English language expressions that are a lot stronger than mere hostility. I'm not that bothered about evincing. As somebody said last week, some of us do live in a world where Victorian vocabulary is fairly commonplace. So if you want to replace evincing with expressing, I'm not particularly bothered about that. But clearly there has to be, on the one hand, recognition that language, speech is behaviour, and the same protections that people have from physical assault should exist for verbal assault as well, and that requires a balancing exercise both as regards intention and negligence and accident, as well as the issues we were talking about before to do with effect. The second point I would make is something that we said a couple of times in our submission, which actually might cut through a lot of this. It's remarkably radical for us, which is the idea that actually we should take out the list of protected characteristics and we should protect anybody who is attacked on the basis of their belonging to any identifiable group, whether it's people with red hair or whether it's cyclists. So why do we give protection to racial groups and then we have to redefine race in the Equality Act to include other categories? We then have an argument about whether they are defined by the census or whether they're defined by people's self-ascription, and there are inconsistencies so that Jews and Sikhs are a race but other religions aren't, and there's an argument about whether Gypsy travellers are a race and so forth. We shouldn't need to have that argument if we spoke in complete generality about attacks on people because of their characteristics that they share with a group. Because what defines hate crime, and you'll find this throughout the literature all the way back to the Lawrence inquiry, what defines hate crime is that it undermines individuals because of their membership or perceived membership of the same group as the initial victim.
Thanks very much, Mr. Borowski. Looking forward to the amendment at stage 2 on protection for cyclists. But can I turn maybe to Ravi Ladva, and then I know Reverend Allison wants it back in and Harbeat Singh. But Ravi.
Thank you. What Ephraim mentioned reminded me of a case in 2019 where vandals attacked a Hindu temple in Walsall, destroying a number of idols and statues that were placed outside. But what it spoke to in particular was that there are aspects of each of our faiths which proselytize and actively seek new converts. If, for example, a Jehovah's Witness, a Hare Krishna, these people are preaching outside, can that be classed as a hate crime because it is not seen, or it's insulting or seen as hateful towards another person's particular faith? And this, extending further from there, for us, it speaks to the danger, if not well-defined, possibility that it could see a retreat of people within themselves and from society, where they are afraid to, express their particular articles of faith because these particular faiths mandate that they should go out and, preach their truth to the world.
Thanks so much. Reverend Allison.
Thank you. I suppose lots of people have said about the widening for the religious freedom of expression clause, and I know that lots of people have, like us in our submission, said that we should have more protected characteristics covered by freedom of expression clauses, such as the transgender stuff. Just to add another area to this that we are concerned about, in relation to the current way in which the sexual orientation is worded, it focuses very much on practice. It doesn't talk about some of the wider issues of identity. And in particular, a concern we have as a church is it doesn't mention any ability to criticise or make comments about same-sex marriage. And given that religious groups have protections to not conduct same-sex marriages, to have their views, we think that there needs to be some reference in the bill to this, like there is in the equivalent English legislation, the Public Order Act.
Hardeep Singh, and then I think back to you, convener.
Thank you. We'd welcome the committee's thought on a point around consideration to extending a list of free speech provisions. So, for example, for journalistic freedom, that would be something that we very much welcome the thought of the committee on.
Okay, thanks very much. Thanks, convener.
Thank you, Liam, and thank you for all of those answers on aspects of the free speech provisions. I want to move on now to a different line of questioning that John Finney is going to take up. John, you've been waiting very patiently. Over to you.
Thank you, convener. Good morning, panel. As in previous sessions, I would like to talk about the subject of aggravations, and there's been a broad welcoming for the statutory aggravation process being maintained. I'd like, in the first instance, if I may, convener, to direct a question to Mr. Borowski about an interesting aspect in his evidence where he covers that, because you are supportive, Mr. Borowski, of that principle. However, you highlight what you refer to as one drawback of the statutory aggravation model. I mean, it might be a self-evident one, namely there needs to be something to be aggravated in the first place, and you detail a number of very unpleasant incidents that you're aware of. But you go on to talk of, we have experience of a prosecution for racially aggravated conduct, and we would urge the proposed legislation should make this option available for incidents such as those that we've described. So this is a question to you, Mr. Borowski, about do you feel that the scope of the bill is inadequate? And then maybe I can broaden that beyond that to ask for a general view of the recommendation that Lord Brackadale had of repealing the racially aggravated harassment offence. That's been maintained by the Scottish Government, and I wonder if members of the panel felt that if it was necessary for race, why not for the other characteristics? So in the first instance, to yourself, Mr. Borowski, please.
Thank you very much for that. Yes, you put the point absolutely precisely that in order to have an aggravation, there has to be an offence that was aggravated. But if you have, unfortunately, to report what you regard as a hate incident to the police, they are as likely as not to categorise it as an incident and not as a crime. And in order to have the perpetrator prosecuted, there are lots of hurdles. You first have to persuade the police that it's a crime, then the police have to persuade the Procurator Fiscal, and if necessary, they have to persuade Crown Counsel and so forth, and then you have to persuade the court. But it doesn't even get to the court. So our concern is, I think, with repeated incidents, not just a one-off incident that could be put down to stupidity or whatever, but where a particular individual has undertaken a course of conduct of low-level harassment, which might actually have a context. One of the examples that we gave was in terms of the harassment of someone who had been a previous complainant, and they are then subjected to repeated harassment over a period of time, none of the incidents of which individually amounts to a crime, and therefore it cannot be aggravated and it can be taken to court. So I think there needs to be specific provision for if you like, a kind of Murov doctrine for hate crime, that if somebody persistently indulges in low-level incidents, particularly if they're directed against the same victim or the same victim group, then they can be aggregated, and that itself constitutes that would constitute the crime which could then be aggravated. So I think that's the answer to your first question. I think the second relates to what I said earlier about having a very general view of a victim group. Hate crime is a crime that is motivated by the victim's membership or perceived membership of a particular group, whatever that group is. And that, together with the principle that has been expressed not just by me, but by others today, and by the Law Society and the Faculty of Advocates last week, and by others, that there shouldn't be a hierarchy of protected characteristics, that the same protections should apply to all.
Okay, many thanks indeed for that, Mr. Brodsky. I'll go to Ms. Ingham-Barrow, please.
Thank you very much. So yeah, obviously I agree with everything that has just been said, and I think just to reiterate the importance of those harassment clauses being extended to cover all protected characteristics. Firstly, due to the kind of the hierarchy of inequality that we spoke about earlier, but also taking the case of Muslims as one specific example, obviously being men's area of expertise. I think there needs to be an understanding of how certain forms of hatred, such as Islamophobia, are a form of racism, that certain groups, such as Muslims, do not get covered by existing protections under the grounds of race. Islamophobia manifesting as a racism means that Muslims have become a racialized group, which for police in particular and prosecution services, it's often difficult to actually decide on how to move forward with a case and where it falls. And obviously that impacts victims, it impacts communities. So I would really support the extension of protections across all protected characteristics.
Okay, many thanks indeed for that. Mr. Singh, Mr. Barber, and then back to yourself, convener. Mr. Singh, please.
Thank you. I just want to make a comment around the aggravation of offences by prejudice. We think the provision in the bill, there's a cover for presumed membership and I think perceived religious affiliation of a group. We think that's a positive inclusion in the bill. And the reason for that is ever since 9/11, Sikhs and many others who I'll describe for the purposes of this as the Muslim-looking other have faced a backlash in retribution for terrorist outrages across the world. And to just illustrate that, I'll give an example of a freedom of information request that we did to the Met Police in London. For 2016, 25% of victims of Islamophobic hate crime recorded by the Met Police were non-Muslims or people of no recorded faith, and the majority of those non-Muslims were Christians, then Hindus. Of course, it included Sikhs, Buddhists, Jews, atheists, agnostics, and others. So I think this aspect of the bill is positive. The only issue around clarity on this is to substantiate aggravation by prejudice. The bill refers to clarity on a single source of evidence. Now, we wanted clarity from the committee as to whether or not that was around the same kind of criteria in the College of Policing's hate crime operational guidance, which for a crime, hate crime to be reported, it's based on the perception of the victim or any other person. The police can't challenge that perception. And no evidence is required. We hope that this is more of an objective test because it could potentially lead to a sentence uplift.
Thank you very much indeed for that. I'm sure that clarity will come at some point. Mr. Barber, please.
Thanks. I was just wondering about the idea that. Well, I mean, my partner's a social worker. I appreciate that crimes committed against somebody because they're hate crimes have a much more damaging effect on the people involved, and they have a much more damaging effect on the community of which they're a part. So they're rightly treated as being a serious crime. But I just wondered if there's not enough protection in Scottish law under the Criminal Justice and Licensing Scotland Act, Section 38(1), which talks about causing a reasonable person to suffer fear or alarm. I mean, that's quite an adequate protection for these things. We have to look at the difference between threatening people and abusing people. I mean, for example, I think that it's you can have a belief that marriage equality is not appropriate. It's not a belief I share, but you can oppose marriage equality as long as you're not actually shipping up at gay weddings with a placard. You know, you can oppose abortions as long as you're not actually guilt-tripping women outside the clinic. There's a difference between insulting and threatening, and I think there's adequate protection in Scots law to protect against being threatened.
Thank you.
Thank you for that very much. Thank you, Convener.
Sorry. Thank you very much. I hope you think your questions have been appropriately answered. Thank you very much. In that case, can I move on to Shona Robertson?
Yeah, just really two questions on the aggravation of offences. You'll be aware that as a general approach to dealing with hate crime, the continued use of statutory aggravations is a core method, and that's been broadly welcomed. And it's see whether anybody wants to differ from that, I guess. But also maybe turning to Mr. Singh first on the second question, and that is on sentence uplift. Mr. Singh mentioned this earlier, that you would have the requirement for more transparency in sentencing, so being able to define what the aggravation is in terms of the sentence. Is that something you agree with, and do you think it's practical? Because we've heard from some of the legal establishment about how challenging that will be to do in practice.
A lawyer, I think the clarity is required around the source of evidence. So is it the same as exists in the current hate crime operational framework, where it's the victim or any other person's perception in order to record a hate crime? So I think that's the kind of clarity that's required. Whose evidence are we talking about when we talk about a single source of evidence in order to substantiate so that would be welcomed for the committee to, give us some clarity on that point.
Okay. Anyone else want to come in on the general point about the continued use of statutory aggravations? Okay. Looks like there's a consensus there. Oh, sorry.
Stephen.
Yes, thank you. Yeah, I suppose on that kind of point about the evidence and the continued use of the aggravation, I think what we're encouraged by is that an aggravation requires the underlying offence to be proven with corroboration. It removes the subjective element. It is, of course, difficult to prove the hatred element. The single source of evidence just makes that a bit easier, but I think I was a former lawyer, and it's always the case that contrary evidence could counteract that piece of evidence. It's not quite that as high a standard as corroboration, but we are kind of content by the fact that corroboration is required for the underlying offence, and so it's really affecting the sentencing, which I think judges always take into account anyway, because you get comments by the bench all the time on how bad a situation was because of particular circumstance to the offence, but it just makes it easier for them to justify those decisions and show because of the hatred is why they've increased the sentencing.
Okay, thank you. Ephraim, I think, wants to come in.
Yes, thanks. Just one very brief point about aggravation, which is about how it's recorded, and this I think runs right through the criminal justice system, is that it's not good enough to record the protected characteristic as listed here in the bill. You have to know, for example, which race is targeted or which religion is targeted. Otherwise, frankly, the statistics are meaningless. You wouldn't be able to identify patterns and trends simply by knowing which of the listed headline characteristics it is.
Okay. Thank you, Convener.
Thank you very much, Shona. We have Ravi who wants to come in on this point, and then after Ravi, it'll be Rona Mackay to pick up the questioning from there. So Ravi first, and then Rona, please.
Yeah, it's just a final point on this aggravation. If it's done from a perspective of ignorance, as a Hindu, a lot of our articles of faith are taken out of context or misconstrued. Would that now be classed as a hate crime? And I think there is scope for organisational awareness and empathy built into this legislation, where people are protected. If it can, to a degree, be proven it was said out of ignorance. And I don't know how other people feel about that, but it's important to us that there is a cure and prevention element to this.
Okay.
Okay, thank you. Rona.
Yes, and in the interest of time, I'm just going to direct my questions to Isabel, to Kieran Turner and to David Bradwell. Is to return to the subject of the different approach to race in the bill. Isabel, can I just ask you to clarify something you said earlier, and it's in your submission. 83% of Muslims have experienced Islamophobia, and you want to see that treated as a separate category. But at the same time, you argue that you want the bill to be uniform and not create a hierarchy of characteristics. Can you maybe just clarify your thought process around that, please?
Yeah, so when we're saying that Islamophobia needs to be recorded as a separate category of hate crime, we're very much pushing for the way in which the police record incidents, because as I was saying earlier, quite often there is a confusion around whether to categorise something as racially motivated or religiously motivated, which causes a problem when it comes to Muslims, particularly because that as was mentioned earlier, we quite often have Sikh communities being targeted, for example. So what I believe forces such as the Met Police do, and it's supposed to be uniform across the whole of England and Wales, but in practice it doesn't always happen. But under the incidents, you have a selection of checkboxes where you can tick all the categories that it could fall under. So I believe anti-Semitism is already recorded, certainly in England and Wales, as a separate category. And we believe that Islamophobia should be as well, purely because when it comes to analysing data and understanding the scale of problems, it allows us to get an accurate picture of what is going on the ground, and then create positive and meaningful policy around these areas. So we're not arguing that Islamophobia should be a separate protected characteristic or anything like that. This is purely to do with how police are recording.
Recording it. Okay, yeah. Thank you for that. That does clear that up. Thanks very much. Can I move on to Kieran Turner, please? Kieran, you in your submission say you want the word insulting removed from this part of the bill, but you also say that you don't want to send a signal that protection against racism is weakened in any way. So I wonder if you could maybe just expand a wee bit on that part, please.
Yeah, of course. Thank you, Ms Mackay. I think it is a very difficult area, and I know it's an area that you have covered over the last couple of weeks in terms of the reference to this different level of threshold with insulting. And I think there's two challenges I think that we see with insulting as it is at the moment. One is perhaps more in relation to nationality and nationalism, and not so much perhaps what we might all associate with racism. And I guess particularly in terms of insult and around things like where that could overlap with political debates, so perhaps things like independence debates, issues around Brexit, and could insult then be carried over and used in that that scenario. I think the other area is around what I touched on earlier in terms of defences, and in obviously the other new stirring up offences, the intent is now required, and therefore I know there's then a conversation about what happens then with the reasonableness test. But in this case, that's not the case, and so we still have a question about the vagueness and I suppose the burden of proof on the accused, or partial burden of proof on the reasonableness test. And so whereas in sections 18 to 21 of the Public Order Act there are specific defences for that to meet that threshold, those aren't there currently. So but I think if the committee, if the Parliament decides that insulting is to stay in, we would argue that actually the specific defence, there should be a more specific defence, essentially to ensure that people don't get caught by mistake from it. So appreciate it's a difficult area, and there are understandable views on both sides, but I think again it's the nationality and it's the defence that I think are the particular challenges.
Thank you. I mean, I just would say that I think context would always be important in these cases, and that would always, would always have to be brought into it. Can I move to David Bradwell, please? In your submission, you believe that it shouldn't be insulting. That's in that part. It should be grossly insulting, and that might, in your submission, you say that might clarify things a bit. Could you maybe expand on that, please?
Well, I think the right to be or to insult and be insulted or cause offence. I think the panel today is agreed that this should be an acceptable part of freedom of expression. I think it's where you draw the line between what can constitute the right to hold strong beliefs that might not fit in with the mores of wider society, to the extent that it can be seen to be causing anger, upset, and hatred. Because we're today a panel representing religion and belief organisations, I think maybe I'll also say that so often race is often used as a proxy for religion, or religion used as a proxy for race in hate crimes. And the particular difference that race is treated in the legislation, I think that is a problem, or when a crime might be directed at someone for their religion, or their race. I think it's maybe also, I don't know if the committee's got plans to hear from other, I'd say, I don't want to call them victims groups, but groups representing people who might be the victims of more prevalent victims of hate crime. And I suppose that from the Church of Scotland, we're in quite a privileged position that we're not often the receiving end of hate crime. But of course, within the Church of Scotland membership, we will have people who are disabled or elderly or LGBT, who will also then, I think, have a question about why race is then going to be treated differently. So I think this exploring the reasons why, I think this is also a very useful piece of work for the committee. I don't really have an answer, but I think I'm glad that you're asking the question.
Okay, thanks very much. I think Anthony wants to come in briefly, Anthony Horan, and then Pardeep.
Thank you. Just on the back of what Kieran was saying, I mean, I think the term insulting, especially given the evidence that the committee heard last week from Lord Brackadale and the Dean of the Faculty, and also Michael Clancy, I think there's a clear suggestion there that the term insulting should be removed, or at least it's not necessary. And we would support that, because I think it's very, very open to wide interpretation. Again, just sort of expanding on what Kieran said about nationality and citizenship, which are covered under the race provisions. So, and I don't think people appreciate what that could criminalise. So, referenda, for example, we're no strangers to hotly contested referenda in the UK over recent years. And those attract very, very robust and sometimes very, very heated exchanges between people on the future constitution of the country. And it would be a hotbed of insults, and all of those insults could potentially be prosecuted under this provision. And I think Andrew Tickell said last week that we live in a culturally contested space. I think that's a very good point. He's absolutely right. And I just think that this legislation needs to be alive to that.
Okay, thank you. I think Hardeep is next.
Thank you. Although we haven't commented on this in our submission, it strikes me that if it's insulting for race only, you're actually creating a hierarchy, and it could be construed as a hierarchy, which suggests that there's a lower criminal threshold. The example, I think, which is helpful to help illustrate this, in 2015 there was a Gurdwara, a Sikh temple in Glasgow, which was vandalised with anti-Muslim graffiti. I won't mention what one of the words is, but one of the subsequent words were "No Sharia," along with a Nazi a swastika scrawled alongside. So, I mean, that potentially is religiously and racially motivated, and I don't see why one or the other should be treated any differently.
Okay, thank you. And finally, Ravi.
For the opportunity. This comes on the back of the tweet that was sent out yesterday by Lord Kilclooney, and it pertains to section, I believe, 36A, which defines a person's behaviour for this piece of legislation. And again, picking up on Ephraim's point, about protecting victims. From the Hindu perspective, over the last number of decades, we've almost been expected to sort of take it on the chin or turn the cheek, and certain things have been portrayed about our community. And I think it's worth including in this legislation that those smaller communities that exist within our country, that exist within our society, are mentioned or afforded protections and support, whether it's legal aid or any other kind that they require, emotional support. Okay, thank you.
Thank you. Thank you, convener. That's me.
Thank you, Rona. Liam, I'm going to give you the chance to come in at the end and ask any follow-up questions that you might want to. But in the meantime, I'm going to move on to Annabel Ewing, who wants to pick up some questions next about hate crime characteristics. Annabel.
Thank you, convener. Yes, just specifically on the issue of, at the present time, the non-inclusion of the characteristic of sex in the bill, both as regards aggravated offences and stirring up offences. I just wonder, and I would go to, in the interest of brevity, Neil Barber, Kieran Turner, Anthony Horan and Hardeep Singh, if either of you have any specific comment you wish to make, whether you feel that the parallel work vis-a-vis looking at a standalone offence of misogynistic harassment is the better path, if you feel there'd be any gap. Yes, so just to elicit some response on that issue. So first of all, to Neil Barber, please.
Well, listen, there are people better informed than me to comment on that, Annabel. I mean, I have personal opinions, but with my National Secular Society hat on, it's sort of beyond our remit, really. I would say that we must remember with this law that there's a difference between, there's this notion that the law is kind of putting out a message, and that the message will not actually filter down at any kind of real level. It's just a sort of guiding message. And I think that's useful, but we must remember that people will take that message and employ it to their own ends.
Okay, next, Kieran Turner, please.
Okay, thank you, Ms. Ewing. Yeah, I mean, so similarly, initial point would be that I think there will be others more qualified than we are in relation to the what would be the most effective way of prosecuting in this area, whether it's a standalone offence or as part of this bill. I suppose my comment would be that if this bill is seeking to consolidate and make clear different areas in relation to hate crime, and broadly to follow the characteristics that are in the Equality Act, it does seem very striking that sex is not part of that, and I guess particularly as Anthony's alluded to in some of the sort of cultural culturally contested conversations that are going on, and perhaps with reference to this one, thinking about the conversation around the Gender Recognition Act and reform of that. It does seem that one aspect of that in relation to transgender identity is covered in this bill, and there is protection. Another aspect of that in relation to sex or biological sex is not covered by this bill. And I suppose the question then really is, does that then do what the bill is seeking to do in terms of consolidate and give everyone equality of protection, and then related to that the framework within free speech and debate and conversation around all of these issues, and so I suppose that would be the question really that I think maybe the committee may want to reflect upon in relation to this.
Okay, thank you for that. Anthony Horan, please, and then Hardeep Singh.
Thank you. Yeah, I think the approach that's been adopted here does give us a fragmented. It appears a bit fragmented in terms of how this has been dealt differently with other protected characteristics. It appears to be at odds with the overall principle of consolidation. But I think given the existing set of protected characteristics, and I don't see why this shouldn't be included, but of course that will be a matter for the working group and their deliberations going forward. I just want to pick up earlier comments in the last session, and there was reference at this point to pro-life vigils outside of hospitals, and now I've got to be. I'm sure that those groups who organise those events can speak for themselves, but I'm not sure of any incidents of harassment or abuse or threatening behaviour. But I think actually what this really does is highlight the very, very important point about balancing fundamental freedoms that we need to take into account. And in that precise situation, very, very important to bear in mind freedom of assembly and free expression, always, of course, set against and balanced against the right for people to freely go about their business without any harm.
Thank you for that. Indeed, it is always a balancing act, is it not? I think our discussions this morning have well demonstrated that. Hardeep Singh, and then after Hardeep, Isabel and Stephen wanted to come back in briefly.
Annabelle, we haven't actually given any consideration to this in our submission. I guess my only sort of comment around this would be it'd be something that would be left to the experts in the working group, but also some consideration to what other characteristics could therefore also be included or given consideration to. People with ginger hair, goths and other subcultures. I know there's been sort of conversations around this in England and Wales. I'm sure that other communities would also like to be part of this conversation as well.
Okay, thank you. And Isabel, and then Reverend Stephen Allison. Thank you.
So most of what I was going to say has actually been covered in terms of the consolidation, and it doesn't seem to make it entire sense that sex would not be included, and also reiterate the point of the need to protect where there are conflicts between different rights of different groups of people. The only other thing that I would add is perhaps there needs to be greater discussion surrounding how abuse against different characteristics intersects. So, for example, how misogyny also, there's an interplay between misogyny and obviously using our expertise, the example of Islamophobia, and Islamophobia is a gendered phenomenon where misogyny definitely plays into some of the attacks that we see. Women are overwhelmingly the victims of particularly violent hate crime against Muslims. So just to point that out, that perhaps there needs to be an understanding of the intersection between hatred against different characteristics.
Thank you for that, Isabel. And Reverend Stephen Allison, finally, please. Thank you.
Thank you. Yeah, a lot of what Isabel was going to say about the conflict between protected characteristics is what I wanted to highlight, and I think it is an issue. And I think the exclusion of sex with the inclusion of transgender does create a kind of hierarchy that it says one is more valuable when there's been such debates and discussions over gender identity issues, and also the lack of a free speech clause on transgender plays into that. So I think there is a lot to be said for sex being treated on the same level as transgender issues here.
Okay, well, thank you all very much indeed for your thoughts. Thank you, convener.
Thank you, Annabelle. And I think we're going to go to James Kelly next to ask a slightly different line of questioning. James.
Thanks a lot, convener, and good afternoon to the panel. I wanted to look at the issue of, do you feel there are any additional measures, legislative or otherwise, that should be introduced to protect those that are victims of hate crime? So what I want to do is go to Harjeet Singh first of all, then Kieran Turner, and then Anthony Horan. If there's anybody else who wants to come in, we can take them. So Harjeet first, please.
I don't have any suggestions for any extra provisions to protect victims of hate crime. I would have, and sorry to go slightly off piece, I would have a suggestion to have a dwelling defence to protect free speech for conversations that happen in the home, as there is in parallel legislation in England and Wales.
Okay, thanks for that. Kieran Turner.
Thank you, Mr. Kelly. I think, yeah, I mean, I don't know if I have specific examples to add. I guess what I would flag up, though, is the ability of all of us, in fact, all of us around this table, representing the diverse groups that we're in, to tackle hatred within our own communities, wherever that manifests itself. And so I don't think it'll be lost on the panel that we're actually having this session in the middle of Scottish Interfaith Week. And many of us on this panel will regularly be mostly in online forums at the moment, engaging with government around various different issues. And so I think I would advocate other non-legislative approaches in terms of tackling the issue generally, as well as perhaps speaking, as I'm sure you will do, in terms of for victims groups, for those who have been victims of hate crime, to see what other support can be given to them.
Okay, thank you for that, Mr. Turner. Anthony Horan.
Thanks, Mr. Kelly. Yes, I don't really have any specific examples, a bit like Kieran, but I think really it's very, very important for Parliament to listen to the wisdom of victim support groups here, and to take full cognizance of their recommendations, because they are the people on the ground. They are hearing what victims are experiencing. So we certainly would want to support that. And just more broadly, I think we need to, all of us, and I think Kieran touched on this, we all need to engage in our social responsibility and discourage hateful behaviour, which hopefully will reduce crime in this kind of in this area, and as I say, support victims of those crimes.
Okay, thanks for those answers. Thank you.
I think Neil, David, and Isabel wanted to come in on this issue as well, if I've read this right. So Neil first, and then Isabel, then David, please.
Thanks. Can I just say, well, as a secular campaigner, it won't surprise you to hear that I feel this, but I think it's a gross act of bolting the stable door to criminalise hate speech on football terraces from young laddies, silly young laddies, when for 16 years they've gone to them and us schools. I mean, let's look at changing hate speech based on these very basic things. Let's not criminalise what is manifest of the sectarianism that is Scotland's shame.
Okay, thanks for that. David?
So, let's go to Isabel first, and then David, please. Isabel, sorry.
Oh, thank you, sorry. Yeah, so I think I've got a whole plethora of potential policy developments and activities that could help in these areas. In terms of the legislation itself, I think somebody else in their submission mentioned anonymity clauses that I believe would really help victims to come forward and report their experiences. I've already mentioned the recording of Islamophobia as a separate category of hate crime by the police. Then we have issues to do with police engagement with local communities and increasing diversity amongst the force and increased understanding. But then there are wider societal issues. So things to do with encouraging kind of political maturity and particularly political representatives using divisive language in their statements. I think that's something that we should be looking into. Looking at school curriculums and how they encourage, decolonizing education, decolonizing narratives, encouraging shared senses of history, and highlighting the contributions of different minority groups to society. I think that's really important at the moment. It's Islamophobia Awareness Month, which is all about encouraging recognition for the challenges that face Muslim communities, but also the contributions that they have made through society. A recognition, and within that we can talk about a recognition of the lasting impacts of colonialism and things like this. Also, there are policies that we need to look at to do with bullying in schools, encouraging teacher training on how to deal with religiously and racially and other forms of age-motivated bullying. So I think, honestly, my time is short, so I would be quite happy to send a very long list of recommendations to the committee of wider areas outside of the bill that could potentially be implemented to help with hate crime.
Thanks, Isabel. Sorry,
go ahead.
Thanks, Isabel. That was very comprehensive, and obviously would be very useful to get a submission on that. And finally, David, sorry for cutting across you, convener.
Thank you, Mr. Kelly. And I think likewise, I'd be very happy to supply you and the committee with some of the examples of work that the Church of Scotland is doing, either supported nationally or being delivered locally to tackle issues of hate speech, of anti-sectarianism work which seeks to overcome violence against women, as well as promoting things around intercultural dialogue and refugee integration. In terms of a role for Parliament and for government, of course the Scottish Government run their One Scotland campaign, which is very, I think, clear about what direction they would like society to go in. I've had some experience with the New Scots refugee integration strategy before, and the way that it brings together representatives of refugee organisations, statutory agencies, voluntary groups offering support, and civil servant and government backing, really brings together everybody who might have an involvement in that issue. And that might be an interesting model to look at when policymakers are developing government strategies and funding opportunities for community work, as well as kind of political statements to work on hate crime. So absolutely legislation is necessary, but actually the first step has to be with people in communities. Thank you.
Thanks for that, David. Some very good examples there. And again, if you've got further information, it would be useful for the committee to have that. Thanks, convener.
Thank you, James, and sorry for speaking across you there a couple of times. Fulton McGregor next, please, and then after Fulton, it'll be Liam Kerr, and I think that will wrap the session up. So, Fulton, over to you, please.
Thanks, convener, and good afternoon, panel. I've got two questions. One specific on sectarianism and a more general one. Well, you'll know that the bill does not include any specific provisions for dealing with sectarianism. And I'm wondering if the panel think that the hate crime characteristics of race and religion is suitable for labelling offending motivated by sectarianism, or do you think there should be something more or less done in this area? And I wonder, in the interest of time, if I could come to Anthony Horan and David Bradwell, perhaps, although if anybody else wants to come in, just as usual, put a wee R in the box. That would be ideal. Anthony?
Thanks, Mr. McGregor. Well, I would tend to go with Lord Brackadale's view on this. I think that sectarianism is generally adequately covered under existing offences and aggravations. And I think Lord Brackadale's words where there isn't any gap in the law. So, but whilst we acknowledge that there is a sectarianism problem and we all have a role in tackling that, it's perhaps better to be a bit more explicit to ensure fair labelling of sectarianism. So if it is anti-Catholic, then say it is so. If it's anti-Protestant, then say that too. And as Fraser Sutherland referred to, I think, in the earlier session, of course, sectarianism doesn't just exist between Catholic and Protestant, it exists between faiths as well, other religious groups. But I think I would defer to Lord Brackadale and rely on the existing criminal law provisions. But I think an important point I'd like to make as well here is that nobody learns sectarian behaviour from the priest or the minister on a Sunday.
Thanks, Anthony. A powerful point, well made. David, are you want to say anything on this?
Happy to say I'm in full agreement with what Anthony just said, and you can rest assured that we will be monitoring this issue as we have done before and in the future, and it might be even a subject for a future Justice Committee inquiry, assuming this legislation is passed, that maybe in a few years we'll do some more investigation as to how it's outworking, particularly on the issue of sectarianism.
Okay, excellent. I see one R, Ravi, is that you want to come in here?
Yes. Thank you. Yeah, it's just on the back of the points that were raised regarding other alternatives, and this particular point regarding sectarianism. As someone who is from Birmingham and relatively new to Scotland, completely, I would say, relatively oblivious to some of the lines that exist within society here. Again, I can be aware of the fault lines that exist within my own background and geographic cities and things like that. But one of the things that we could potentially look at is provide funding to our respective organisations to do consistent outreach and to break down some of these barriers and engage with people on different lines, such as sport, food, other aspects of our culture, to try and bridge some of these gaps and bring people together on different lines. I think that's a serious alternative we should consider.
Excellent, and a very good point to end this particular line of questioning. I do have one other question. I don't know, panel members don't feel the need to answer it, because I know that some of it's already been covered in earlier questions, but it's around the general hate crime characteristics, and I just wondered if any of his panel members have concerns about the way in which various hate crime characteristics have been defined in the bill, and are there any characteristics you think should be added? And I know, for example, we've already had a discussion on sex, for example, but is there anything else there that you feel could be added, or any concerns regarding the characteristics? And I've not actually got into task specifically, so I would just look for some R's, and as I say, if you feel you've already had a say in this, that's okay as well. I think everybody seems content, Convener. I'm happy to pass back to yourself then.
Thank you, Fulton. Thank you for giving the panel the opportunity to come back on that. Liam Kerr, I know you had a couple of supplementaries that we didn't reach earlier. It doesn't matter if we take these out of sequence. It's important that everybody gets to ask what they want to ask. So please feel free to ask what you want and to wrap up. Liam.
Thank you, Convener. I just have the one question on an area we haven't explored yet, which is part 4, the abolition of the offence of blasphemy. Given where we're running on time, I'll ask it in the negative, and anyone can jump in who wishes to. There would appear to be wide support for the abolition of the offence of blasphemy. Are any of you not supportive or have any concerns about the abolition or how part 4 is drafted? If that applies to you, put an R in the box now and we'll come to you. If nobody does that, I'll hand back to you, Convener. Back to you, Convener.
I'm going to resist the temptation to make any bad jokes about self-censorship applying to all of the members of the panel, none of whom want to object to the abolition of the offence of blasphemy. Indeed, the written evidence that you already sent the committee is very strong and clear on this. Can I just close this session then and thank you all so much for the time and consideration you've brought to bear on this bill. From a huge variety of different faith backgrounds and non-faith backgrounds, and you have really helped the committee to understand some of the implications of what we're dealing with in this legislation. If there are any issues that any of you want to reflect further on and come back to the committee on, please do feel free to do that. I know that not everybody was able to say as much as they might ideally have wanted on every question, but if there's anything that we have not enabled you to say today, then please do come back to us. But thank you very much indeed for your help and for your time. And I now, our next meeting, I should say, will be a week today on Tuesday the 17th of November, which, like today, will be a virtual meeting, and we will continue to take evidence at stage 1 on this bill. We intend to start at 9 o'clock. On Tuesday next week. I now bring this public part of our meeting to a close, and members should sign off from BlueJeans and sign on to Teams, please, so that we can take the next item in private. But thank you all very much indeed for your help today. Thank you.